Yes, sir.
I told you.
Mr. Speaker, you have the floor.
The Senate will come to order. Mr. Sergeant at Arms, invite the members in and close the doors. Representative Matlock, come on up here. Will the members and guests please stand for the invocation and thereafter stand for the Pledge of Allegiance and the salute to the Tennessee flag led by Senator Wally. Senator Wally, you're recognized to introduce the Minister of the Day, Pastor Alan Geyer, and after that to do the Pledge of Allegiance and the salute to the Tennessee flag. Senator Wally.
Mr. Speaker, thank you so very much. It's my great honor, members and guests, to introduce you to Pastor Alan Geyer, pastor of the Riverview Baptist Church of Savannah, Tennessee. He's been the pastor at Riverview for 12 years. This July, he'll be celebrating his 40th year in the ministry, and we're so very proud of him. Alan and his wife, Christy, who's here with him today, have been married for 36 years. They have 3 children, 2 grandchildren, and another grandchild due in August. And let me say, Mr. Speaker, that Pastor Allen is a remarkable inspiration to those of us that attend his church. As you'll notice, and I'm going to just say something a little personal, Allen, as you'll notice when he speaks, his voice has been affected by a cancer that he has overcome. It has impacted his vocal cords. He is doing amazingly well. God has his hand on him because he has a lot more to say, and he leads the singing as well. So we're so grateful for what God does in your life, Pastor, and would you please now lead us in a word of prayer? Thank you, Mr. Speaker.
Thank you, Senator Wally. Pastor Geyer, you're recognized at the podium.
Thank you. It's a joy to be here and an honor. Thank you. Let's pray. Lord God, you are good. Your mercies are new each and every day. Great is your faithfulness. And oh God, thank you for the privilege of being an American. And I'm so thankful to be a lifelong Tennessean. And your word says in Romans 13 that you have instituted government. And these men and women who represent and serve our state today have a tremendous and weighty responsibility. Lord, I thank you for their willingness to offer themselves in service and leadership to our state. May they lead with a righteous clarity today. Give our senators godly wisdom and guidance, strength, courage, and humility and unity as they are in session today. Lead them in the way that they should go. Counsel them with your eye upon them. I pray for your blessings and your protection upon them and their precious families. God, your word says in Psalm 33 and verse 12, blessed is the nation whose God is the Lord. Heavenly Father, we honor you. We love you. And most of all, thank you for sending your Son, Jesus Christ, to pay the price for our sins and extend forgiveness and grace to all. I pray all of this in the mighty name of Jesus, my Lord and my Savior. Amen.
Amen. Senator Wally. Roll call, Mr. Clerk. I'll introduce you in just a minute. Yeah, just stay here for a minute. Mr. Clerk, take the roll.
Mr. Speaker, 33 members are present.
Pursuant to Article 2, Section 11 of the Constitution of the State of Tennessee, the Senate has a quorum and is now in session. Just a personal note, I'd like to introduce to the Senate Mr. Jimmy Matlock. He's from Loudoun County, and he'll be running for my seat for the Senate 5th District. He had served in the House of Representatives and was a great help to me when I ran and just inherited 2 new counties, Loudoun and Monroe. He's a businessman and a great person, be a great addition to the Senate. So please give him a hand. Senator Campbell, you're recognized.
Thank you, Mr. Speaker. Permission to approach the well, and Mr. Sergeant at Arms, would you please invite my guest to join me in the well?
Senator Campbell, you may approach the well, and Mr. Sergeant at Arms, please bring the guests to the front. Senator Campbell, you're recognized.
Thank you, Mr. Speaker. Colleagues, please join me in welcoming Ariana Smith, a Nashville Big Picture High School student, 12-year Boys and Girls Club member, and the 2026 Tennessee State Boys and Girls Club Youth of the Year. Wow. I believe the clerk is going to read some highlights from her resolution.
Mr. Clerk.
Senate Joint Resolution 899 by Senator Campbell, a resolution to honor and commend Ariana Smith upon being selected the 2026 Boys and Girls Club of Tennessee State Youth of the Year. Whereas it is fitting that the members of this General Assembly should pause in their deliberations to salute those young citizens who, through their remarkable efforts, have distinguished themselves as emerging community and state leaders of whom we can all be proud. And whereas one such deserving person is Ariana Smith, who was recently named the 2026 Youth of the Year for the State Boys and Girls Club of Tennessee, a most befitting honor that recognizes her leadership, community service, and perseverance. And whereas a member of the Boys and Girls Club North Nashville Teen Center, Ariana is a student at Nashville Big Picture High School. And whereas she has been a member of the Boys and Girls Club for 12 years, during which time she took part in the Summer for America's Youth, flying to Washington, D.C., and spoke with the Tennessee congressional members about food insecurity issues. And whereas in addition to participating in the Boys or Girls Club, Ariana Smith is a member of the Fellowship of Christian Athletes and serves as a creative director and event planner at her high school, in addition to maintaining a job at a local restaurant. And whereas upon graduation, she plans to attend Belmont University to pursue a degree in nursing with the ultimate goal of serving as a pediatric nurse. And whereas the Boys and Girls Club exists to serve youth and to provide a safe place for encouragement, character building, security, and love for children. And whereas the success of this state, the strength of our communities, and the overall vitality of American society depends in great measure upon the dedication of young people such as Ariana Smith, who use their considerable talents and resources to serve others and who would be specially recognized for their public and community service. Now, therefore, be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, that we honor and commend Ariana Smith upon being named the 2026 Tennessee State Boys and Girls Club Youth of the Year, and we extend her our wishes for every future success.
Thank you. Please join me, colleagues, in congratulating Ariana on this incredible achievement.
Senator Lowe, you're recognized. Just a second.
Thank you, Mr. Speaker. I had the privilege of attending the Youth of the Year competition and watching this young lady deliver her speech. Her story is inspiring. She's going to go represent us at the next level in the Southeast, and we've had a couple of Southeast winners in recent years, and we hope to see you go all the way to D.C.
Thank you, Senator Lowe. Thank you. Ms. Smith, thank you. We appreciate you. Orders of the day, Mr. Clerk.
Introduction of bills.
Leader Johnson, you're recognized.
Thank you, Mr. Speaker. Members, good morning. Proper notice having been given, I move that pursuant to Senate Rule 32 and Article 2, Section 18 of the Constitution of the State of Tennessee, Senate Bills 2724 and 2726 be passed on first consideration.
Without objection, the Senate bills are passed on first consideration. Without objection, motion to reconsider is hereby tabled. Next order, Mr. Clerk.
House bills on first consideration.
Thank you, Mr. Speaker. Proper notice having been given, I move that pursuant to Senate Rule 32 and Article 2, Section 18 of the Constitution of the State of Tennessee, House Bills 166, 803, 1500, 1645, 1665, 1704, 1705, 2020, 2355, and all bills received today pass first consideration be referred to the appropriate standing committee designated or held on the clerk's desk.
Bills are introduced, passed on first consideration, and are held on the clerk's desk. Without objection, motion reconsider is hereby tabled. Senator Hatcher, you're recognized.
Thank you, Mr. Chairman, or Mr. Speaker. I have some guests today with us here from Monroe County. It's a group of seniors and teachers. If they would stand, they represent Tellico, Sequoia, and Sweetwater High Schools. Help me make them welcome.
Thank you, Senator Hatcher. Glad to have you with us. I once represented Monroe County, but now you've got a good senator. Next order, Mr. Clerk.
Speaker, there are no Senate bills on second consideration. Introduction of resolutions.
Leader Johnson, you're recognized.
Thank you, Mr. Speaker. Proper notice having been given, I move that pursuant to Senate Rule 21, Senate Joint Resolutions 943, 945 through 956, and Senate Resolutions 347 through 348 be introduced, passed on first consideration, held on the clerk's desk.
Without objection, the resolutions are introduced, passed on first consideration, and are held on the clerk's desk. Without objection, motion reconsider is hereby tabled. Next order, Mr. Clerk.
Resolutions lying over.
Leader Johnson, you're recognized.
Thank you, Mr. Speaker. Proper notice having been given, I move that pursuant to Senate Rule 21, Senate Joint Resolutions 935 through 942, Senate Resolutions 343 through 345, House Joint Resolutions 727, 751, 1083 through 1093, 1096, 1098 through 1106, and 1133 lie over, be referred to the appropriate standing committee designated or held on the clerk's desk.
Having laid over, the resolutions are referred to the appropriate standing committees designated or held on the clerk's desk. Without objection, motion reconsider is hereby tabled. Next order, Mr. Clerk.
Unfinished business and notices.
Senator Pody, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, I have several guests with me today. Oh, Mr. Speaker, let me tell you, I've got 58 guests up in the gallery and one guest here. This is from the Leadership Wilson class. They tell me it's the best class ever. And Dory Mitchell is right here. This is her 19th year coming down, leading the Leadership Wilson. If I could get our Wilson County, would you all please stand? Please
Wilson
make them welcome.
County. Thank you, Senator Pody. Senator Rose, you're recognized.
Thank you, Mr. Speaker. I also have guests today. I share these with Senator Taylor. We have from Bartlett Alderman Kevin Quinn and his daughter Elizabeth, and they are somewhere in the gallery. If you're here, stand up. If you're not, we'll welcome you later. Oh, they're in the back. I'm sorry. They're in the back of the chamber.
Glad to have you with us. Senator Stevens, you're recognized.
Thank you, Mr. Speaker. I would like to introduce my pages of the day from Hollow Rock Brewston Central High School, Miss Stella Higdon and Avery Hollingsworth. Stella Higdon is a junior, and she is involved in a multitude of academic clubs, social organizations, and she is a varsity cheerleader. Outside of high school, she enjoys spending time with her friends and family, advocating for a cause close to her heart, such as animal rescue, and participating in pageantry. That is a lot of alliteration that I struggle with. Avery Hollingsworth is also a junior and involved in numerous academic clubs and participates also as a high school varsity cheerleader. She also enjoys times with friends and family and traveling to new places. She is escorted today by Stella's grandfather, Mr. Gary Wicker. Please make them welcome.
Glad to have you with us. Senator Wally, you're recognized.
Mr. Speaker, thank you very much. I'd like to move, Mr. Speaker, to suspend the rules for the immediate consideration of HJR 131. It is a memorializing resolution for a gentleman that passed away, a close friend of Representative Gantz, and he's asked me to expedite this so that he can have it for the funeral services upcoming.
The motion is to suspend the rules. Is there objection? I see none. Without objection, the rules are suspended. Senator Wally moves adoption. House Joint Resolution 131. It's properly seconded. Senator Wally.
I'm sorry, Mr. Speaker, it's 1131. 1131. HJR 1131.
Excuse me. It's properly seconded. All those in favor say aye. Aye. Opposed, nay. You adopt. Motion reconsider is hereby tabled. Senator Lamar.
Thank you, Mr. Speaker. I just wanted to recognize my special guest, my better half, Mr. Randy Dixon, Mr. Randy Dixon is here today. Thank you, and make him feel welcome.
Glad to have you with us. Senator Gardenhauer.
Thank you, Mr. Speaker. I want to suspend the rule by Rule 83-8 and bring Senate Bill 1183 out of General Subcommittee and place on the Judiciary calendar this week.
Motion is to suspend the rules, and that's for Senate Bill
1183.
1183. It's properly seconded. Is there objection? Without objection, the rules are suspended. Senator Gardenhauer moves that it be placed on the Judiciary calendar for this next week. It's properly seconded. All in favor say aye. Aye. Opposed, nay. You adopt. Thank you. Thank you, Senator Gardenhire. Next order, Mr. Clerk.
Mr. Speaker, the Senate's on the calendar. The Senate has a consent calendar memorializing resolutions.
Senator Powers, you're recognized for the consent calendar.
Thank you, Mr. Speaker. Mr. Speaker, spread upon the member's desk is a consent calendar of memorializing and congratulating resolutions. A member has asked to bump number 29 from the calendar. If there are no further changes or objections, I move adoption.
Motion is for adoptions, properly seconded. Is there any objections? I see none. All in favor of consent calendar number 1 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 32, no nays.
The consent calendar, having obtained a constitutional majority, I declare it passed without objection. The motion reconsider is hereby tabled. Next order, Mr. Clerk.
Speaker, we have consent calendar number 2 of general bills.
Consent calendar number 2. Chairman Powers, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, also spread upon the member's desk is consent calendar number 2 of general bills. If there are no changes or objections, I move adoption.
That's the proper motion, properly seconded. Any changes or objections? Senator Crowe? No. Oh. Consent calendar number 2. Having been properly moved and seconded, all those in favor of consent calendar number 2 vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 32, no nays.
Consent calendar number 2, having received a constitutional majority, I declare it passed. Without objection, the motion to reconsider is hereby tabled. Next order, Mr. Clerk. I'm sorry, Senator Crowe and then Senator Wally. Senator Crowe.
Thank you, Mr. Speaker. We're very proud today to have in the gallery our leadership, Johnson County, our easternmost county. You know, many times they're forgotten. They say the buck stop in Knoxville, but we don't let that happen, right?
Right.
All right, they're in the gallery. We're proud of them. Thank you.
Johnson County, please stand up and we'll recognize you. Thank you, Senator Crowe. Senator Wally.
Thank you, Mr. Speaker. If I might also be recognized out of order to introduce a group.
Senator Wally, you're recognized for that purpose.
Thank you, Mr. Speaker. I have the group Leadership Lawrence County that just arrived, and I was informed that they had joined us in the balcony. So if they might stand and we could welcome them. They do a great job for us in Lawrence County. So thank you all for being here, and we welcome you.
Glad to have you with us. Thank you, Senator Wally. Senator Bailey.
I'm sorry.
Oh. Next order, Mr. Clerk.
Item number 1, Senate Joint Resolution 618 by Senator Gardenhire on 3rd reading.
Senator Gardenhire, you're recognized on Senate Resolution 618.
Thank you, Mr. Speaker. Third and final reading of SJR 618.
Mr. Clerk, read the resolution.
Senate Joint Resolution 618 by Senator Gardenhire, a resolution to propose amendment to Article 6, Section 4 of the Constitution of Tennessee regarding the residency requirement of judges. Be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, that a majority of all the members of each House concurring, as showed on the yeas and nays and on their journals, that it is proposed that Article 6, Section 4 of the Constitution of Tennessee be amended by deleting the following language. Every judge of such court shall be 30 years of age and shall before his election have been a resident of the state for 5 years and of the circuit or district for 1 year, and substitute instead the following. Every judge of such courts shall be 30 years of age and shall, before his election, have been a resident of the state for 5 years and a resident of the county of the respective circuit or district to which the judge is to be assigned for 1 year. Be it further resolved that the foregoing amendment be referred to the 115th General Assembly, that in accordance with, in resolution proposed such amendment be published by the Secretary of State in accordance with Article 11, Section 3 of the Constitution of Tennessee by proposing such amendment on the official website of the Secretary of State and the official website of the General Assembly.
Senator Gardner.
Thank you. I move that we adopt this on third and final reading. Thank you.
Senator Gardner moves adoption on third and final reading. Discussion. Objection to the question. Senator Yarborough.
Thank you, Mr. Speaker. If the sponsor could just try to lay out briefly, like what's the real change that's being enacted by this amendment? What problem is it solving? What's the purpose? I'm just have missed that.
Senator Gardner to respond.
Thank you, Mr. Speaker. There was a lawsuit over a candidate that was running for judge that didn't live in the district to which they're running. It was a big county with multi-jurisdiction municipal courts and stuff. And they ruled that you had to live in the municipality where you were going to be a judge, and that's changed the way all these municipal judges in large counties were elected. And so this just corrects that problem to where you have to live in the county instead of the municipality or the district to which you're going to be a judge over. It threw a lot of small cities with nobody to sit as a judge over their area, and they all had to go to Sessions Court, which tied up a lot of personnel, police officers, and everybody else to have to go down to the Session Courthouse, the regular courthouse of Sessions judges, instead of having a municipal judge in their city, like East Ridge or Collegedale or Red Bank in Hamilton County. And probably the same thing hit Davison County that you have. And this just corrects this and says you have to live in the county to which your municipality or your judgeship is instead of in that little bitty town. That's what this corrects.
Senator Yarborough.
Okay, so this would allow, I mean, I'll use the sponsor's example. So if there's a municipal judgeship in East Ridge, this would allow someone who lived in Chattanooga proper or in Collegedale or some other portion of the city to run for that judgeship regardless of whether or not they live in East Ridge. That's the purpose?
Senator Gardner to respond.
That is correct.
Further discussion. Objection to the question? See none, all in favor will vote aye when the bell rings. Those opposed to vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 29, no nays.
Pursuant to Senate Rule 21, Article 11 of Section 3 of the Constitution of the State of Tennessee, Senate Joint Resolution 618 having been read for the third time. Having received a constitutional majority, the Senate adopts Senate Joint Resolution 618. Motion to reconsider is hereby tabled. Next order, Mr. Clerk.
Item 2, Senate Joint Resolution 624 by Senator Johnson on third and final reading.
Leader Johnson, you're recognized.
Thank you, Mr. Speaker. Would you please direct the clerk to read the resolution for the third and final time?
Mr. Clerk, please comply with the request.
Senate Joint Resolution 624 by Senator Johnson. A resolution proposed amendment to Article 4, Section 1 of the Constitution of Tennessee to specify that only citizens of the United States may vote in state, county, or municipal elections. Be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, the majority of all the members of each House concurring is shown by the yeas and nays entered on the journal, that it is proposed that Article 4, Section 1 of the Constitution of Tennessee be amended by deleting the section in its entirety and substituting instead the following. Every person being 18 years of age, being a citizen of the United States, and being a resident of the state for a period of time as prescribed by the General Assembly, and being duly registered in the county of residence for a period of time prior to the day of any election as prescribed by the General Assembly, shall be entitled to vote in all state, federal, and local elections held in the county or district in which such person resides. All such requirements shall be equal and uniform across the state, and there shall be no other qualification attached to the right of suffrage. No person who is not a citizen of the United States shall be entitled to vote in any election held in this state, including elections for state, county, municipal, or district offices, or any ballot measure, referendum, or other questions submitted to the people. The General Assembly shall have the power to enact laws requiring voters to vote in election precincts in which they may reside, and laws to secure the freedom of elections and the purity of the ballot box. All male citizens of the state shall be subject to the performance of military duty as may be prescribed by law. Be it further resolved, the foregoing amendment be referred to 150 General Assembly that this resolution proposes such amendment be published in accordance with Article 11, Section 3 of the Constitution of Tennessee by posting such amendment on the official website of the Secretary of State and on the official website of the General Assembly.
Leader Johnson.
Thank you, Mr. Speaker. Move adoption of Senate Joint Resolution 624 on third and final reading.
That's a proper motion, properly seconded. Discussion. Is Senator Yarborough.
Thank you, Mr. Speaker. And I just want to give if the sponsor wants to give any overview before I ask questions, I'm happy to hear it.
Leader Johnson.
Thank you, Mr. Speaker. It's a pretty simple resolution. Our Constitution, state Constitution now is silent relative to a citizenship requirement to participate in elections in Tennessee. We do address that in statute, and we require that you be a citizen, but I believe it rises to the level that it should be enshrined in our Constitution.
Senator Yarborough.
Thank you, Mr. Speaker. So the requirement that only citizens vote is already absolutely a requirement by federal law, which it has been for decades. I'm not familiar with any attempts to revise that. The Tennessee law is equally clear through statutes that this legislature has adopted that citizenship is a prerequisite for voting. And I don't think it's actually true to say that the Tennessee's, like the current version, is entirely silent. We actually spell out that you have to be a qualified elector under the statutes this body devises. We're literally changing nothing in this legislation. And I mean, this is the Tennessee Constitution went from 1870 to like 1950 something with 0 amendments. We have amended the Constitution more in the last couple of legislatures than we did for the first 100 years of this Constitution. And for a constitutional amendment that literally changes nothing, changes no rule of government, I mean, we're just using the Constitution as sort of a messaging vehicle at this point. And I mean, like, this is the law. There's no proposal to change it. And so, especially given the number of amendments that are pending, I'm not sure why we would do this.
Further discussion. Is there objection to the question? I see none. Leader Johnson to close.
Thank you, Mr. Speaker and members. I certainly respect the legal acumen of my good friend and colleague from Davidson. However, that legal interpretation of our Constitution is in question. And there are those who opine that, in fact, a future General Assembly could, via statute and a statutory change, allow non-U.S. citizens to vote in our Tennessee elections. Like so many things in the Constitution and in law, there is some ambiguity, at least in the eyes of some legal scholars, which is why I believe we should take this action and put it before the voters of Tennessee. and let them decide if they think it is warranted to enshrine the integrity and the protection of our electoral process in our Constitution. I appreciate a favorable vote, Mr. Speaker. Thank you.
We'll be voting on Senate Joint Resolution 624 on third and final consideration. Those members voting in favor will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 27, nays 4.
Pursuant to Senate Rule 21 and Article 11 of Section 3 of the Constitution of the State of Tennessee, Senate Joint Resolution 624 has been read for the third time. Just a second. Having received a constitutional majority, the Senate has adopted Senate Joint Resolution 624. Motion to reconsider. You don't have a motion to reconsider, do you? Goes to the table. Senator Crow.
No, thank you. I don't. I just wanted to add a little force to what the leader just said. If you recall, in thinking about what a future legislature might do with something like this, you and I served with Governor Ned McWhorter for many years, and if you will recall, he used to say, with 17 in the Senate and 50 in the House, you can sell the dome off the top of the Capitol. I remember him saying that. The same goes for a supermajority vote as well. So this is a safety measure. And the previous bill, thank you, Mr. Leader, for bringing this up.
Thank you, Senator Crow. Senator Powers.
Thank you, Mr. Speaker. If I may be recognized out of order.
You may.
Today I have my intern with me. Stand up, Alex. This is my intern for the year, and she's been a real joy to have. Her name is Alex Tedderington, and she is a senior at Austin Peay and graduates in May with a political science degree. She hails from Gallatin, the home of Farrell Hale, and also Mr. Stevens down there. But she does live in Gallatin, and she's been a joy to work with, as well as a hard worker. She's here today. Her mother's up in the gallery. Let's please make them welcome.
Glad to have you with us. Thank you, Senator Powers. Next bill, Mr. Clerk.
Item number 3, Senate Bill 303 by Senator Pody on third and final consideration. Mr. Speaker, the House bill is on the desk.
Senator Pody, you are recognized on Senate Bill 303.
Thank you, Mr. Speaker. I move to conform and substitute for the purpose of bringing up an amendment.
Motion is to conform and substitute to House Bill 47. Is there objection? Without objection, we're on House Bill 47. Senator Pody moves adoption. Properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Education Committee amendment.
Chairman White, you're recognized on amendment number 1, Education.
Thank you, Mr. Speaker. Amendment 1 will require LEAs and charter schools to display the 10 Commandments, the first sentence of the second paragraph to the Declaration of Independence, and the preamble to the U.S. Constitution together in a prominent location. Move to adopt.
Motion is to adopt. Is there discussion? See none, all in favor say aye. Aye. Opposed, nay. To adopt. Amendment number 1. On the bill. Discussion. Senator Yarborough.
Thank you, Mr. Speaker. I believe the sponsor was seeking recognition. I want to yield to him before commenting.
Senator Pody.
Thank you. So what we're doing here is we're taking historical documents and the Declaration of Independence, portions of that. We're taking portions of the Constitution as well as the 10 Commandments, portions of Genesis from the book of the Bible, and we're just going to be having those as historical documents for the founding of this nation and put them one in each of our schools.
Senator Yarborough.
I guess my question for the sponsors, given that at least one of the documents is exclusively, is fundamentally a religious text, why would we include that on the walls of every school in the state?
Senator Pody to respond.
Thank you. Thank you for the question. It's interesting that of the 3 documents we've chosen, of the 13 colonies that formed this nation, the Declaration of Independence was not in there when we formed our nation, nor was the Constitution. But what was in those 13 colonies was the 10 Commandments. And that is one of the basic historic documents that we want to make sure that the founding of this nation was on.
Senator Yarborough.
I mean, just sort of as a historical side there, I mean, the reason it was in those colonies is they were colonies that came from a kingdom that had an established state church. And I mean, one of the very clear decisions that we made as a country was to not do that. And so I guess that still begs the question, like, why would we want to include in schools today a religious document?
Senator Pody to respond.
And that is an interesting point. But of the 13 colonies, many of them actually had state religions. And so when they formed the nation, they said there would not be a state religion, and we would not have that. That way we have the freedom of religion. But this was still a founding document from all 13. This is still a founding document of our nation. And when we formed the nation, the 10 Commandments went into the Capitol. It went into our Supreme Courts. It went into most government buildings, which it's still there today.
Senator Yarborough.
Thank you. Which version of the 10 Commandments would be included?
Senator Pody to respond.
I have not said, I know there's multiple versions out there, and whichever decision somebody would like to put in, but they're all going to say the same 10 Commandments. They're all out of Genesis, and they're all saying the same thing. You shall not kill, you shall not steal.
Senator Yarborough.
Thank you, Mr. Speaker, but I mean, different faiths use different traditions, different scriptures. You have numerous, there are 600 versions of how the 10 Commandments are written. And I think ultimately we end up choosing one, and we put how is that choice going to be made?
Senator Pody to respond.
Sure, these are going to be put in by nonprofits, fraternal organizations, and such in coordination with the schools. But they're going to be the ones that are going to be paying for it. But they're all going to say the same thing from Genesis, the 10 Commandments.
Senator Yarborough.
Thank you, Mr. Speaker, and I believe the gentleman was referring to Exodus there. Or it could be Deuteronomy, but it wouldn't be Genesis. But I think that sort of picking and choosing here is not irrelevant. And a lot of these are actually focused on, things that are central to my life, and I know are central to the sponsor's life, but that are not relevant to, frankly, certain other faiths. I just don't, and the fact that we're sort of justifying that because there used to be established churches in the states in the country is frankly alarming. Like that's contrary to what the Tennessee, even to the extent that that's true, that was never true in this state. This state's constitution, since its first draft, was firmly opposed to having any sort of state endorsement of a religion. And I think we would all be better off if this body if we all spent more time trying to follow the Ten Commandments rather than trying to poster them up in every school across the state.
Thank you, Senator Yarborough. Senator Lamar, and then Senator Crow, and then Senator Yeager. Senator Lamar.
Thank you, Mr. Speaker. Will the sponsor yield for questions?
Sponsor yields.
Thank you, Mr. Speaker. My question to the sponsor is, if a particular LEA decides to require the posting of the Ten Commandments, is there a punishment for students who do not want to recognize, follow, or learn anything about the Ten Commandments?
Senator Pody to respond.
I absolutely stand corrected by my good friend from Davis County. It is not in Genesis, it is in Exodus, so thank you for pointing that out. No, there is nothing that says the student has to read it or anything else. We're not trying to make them do anything. So if a student walks right by it, there's nothing in there saying that they have to read any part of the documents whatsoever.
Senator Lamar.
Thank you, Mr. Speaker. Would LEAs also be allowed to post religious documents for other religions besides Christianity, from Muslim, Judaism, Hinduism, Buddhism, or any other recognized religions in this world?
Senator Pody to respond.
This bill does not prevent the LEAs from doing anything that they have the freedom to do right now.
Senator Lamar.
Thank you. My question to the sponsor is, do you feel this piece of legislation is telling students who are not of Christian faith that they are less than, because we are essentially requiring the posting of only one particular religion document versus others? In addition to, my second question is, don't you think this is a violation of church and state?
Senator Pody to respond.
So this is absolutely not a violation of church and state. We are not forcing religion on anybody. We are saying this. We are saying in the founding of this nation, the Ten Commandments was one of the founding documents, one of the founding guidance that our forefathers put into this nation. And that's what we're trying to represent. That's what we're trying to make sure it is taught. For over 100 years, when this nation was founded, it was open, that they were always promoted. It hasn't been until recently, through, I believe, the Supreme Court with the Lemon Test, that it was even questioned at that point. And it looks like that's being overturned at this point.
Senator Lamar.
Thank you, Mr. Speaker. I would just close to say that the reason I'm against this bill is because there are a lot of things that this nation was started on that weren't good things that we have gone away with. But what this bill to me is, it's religious indoctrination. And when I think about the people who founded this country, they were leaving Europe for that same reason, because they were being indoctrinated in teachings that they did not believe in. And they came to America for the idea of freedom to be who you are, freedom to believe your own beliefs, freedom to live the way that you wanted to do. And now it seems that we are actually doing the opposite of what this country was founded to be. This country was made so that folks who are not just Christian, of all religious faiths, could be able to come to this country and be able to live free of discrimination or indoctrination. And now, when many of our laws and court rulings allow the freedom of religion, this bill is now putting a particular religion, or indirectly forcing one religion on a mass group of students. Now, I'm a Christian. I live by the Ten Commandments, so it's not that I don't believe in the Ten Commandments, but I don't think as a legislator it's our right to force Christianity on children in our school system. Our children need to be learning about reading, writing, arithmetic, science, tech, to make them ready to be a world-class generation of kids who can push this country forward, not be indoctrinated to what the Bible says here and there. That is the responsibility of the church, their parents, their families, and whatever private entities they want to engage with in order to believe the teachings of Jesus Christ, not in schools. So with that being said, that is why I'll be voting no on the bill. Thank you, Mr. Speaker.
Thank you, Senator Lamar. Senator Crow.
Thank you, Mr. Speaker. I would remind the body that we have passed legislation to post in all of our schools in a very prominent place, "In God We Trust." The Ten Commandments are the basis of our laws. They're the basis of all of our laws. That's just common sense that we would want to post this in our schools, such that our students who really need as much direction these days as we can give them that we would do this. It's just good common sense, Mr. Speaker.
Thank you, Senator Crow. I have Senator Yeager, Senator Rose, and Senator Sutherland. Senator Yeager.
Thank you, Mr. Speaker. I'm standing in support of the bill, and I'm glad to see the sponsor bring it. The Ten Commandments have a universal application and support from people groups throughout the world. Some, frankly, some perhaps are even not Christian. And the reason for that universal support is that these 10 rules or commandments speak to man's relationship to his fellow man and man's relationship to his God. This bill does not create a state church. This bill does not have forced indoctrination. This bill merely requires that we post these universal rules in our schools, our public schools, and our charter schools. That's all it does. And it is certainly a fitting and just recognition of the importance of these rules as guidelines in our relationship with one another and our God. Thank you.
Thank you, Senator Yeager. Senator Rose.
Thank you, Mr. Speaker. And I know there's been some spirited debate on this, but I just want to remind the folks that it's been documented that the Bible, more than any other document, was the basis for our Constitution. Number one. Number two, the Ten Commandments are displayed today above the Justice's bench in the Supreme Court, on the Supreme Court entry doors. They're on those doors right now. They're on the pediment above the Supreme Court. They're on the floor near the entry of the National Archives. They are displayed in the Library of Congress, all across our nation's capital. Before we allowed people to convince us that the church could not be in the state, there are hundreds of biblical references across our nation's capital. This is a great bill. The folks that came over here were not Muslims. They were not Hindus. They were Christians for the most part. And you can look at the sponsor has said, you can look at those founding documents of the first 13 colonies. They specifically stated their Christian faith. And to my colleague from Shelby, we are not dictating that people adopt what those Ten Commandments say. We're just saying it is permissive. That's all. It's permissive to put them in a school setting. I know that Senator Sutherland has asked to speak, but if he has not, I would call for a question. And again, thank you for bringing the bill. Thank you.
Thank you, Senator Rose. Senator Sutherland.
Thank you, Mr. Speaker. I'm sitting here looking at the Ten Commandments that was placed in the Greene County Courthouse, stated March the 15th of 1999, and they said they would never stand every lawsuit. So that's been over 27 years ago. It's still standing. When you look at other different religions, they have different books that they believe in posted in their schools. And so I'm thoroughly 100% in this. This has stood for over 27 years in the Greene County Courthouse. Thank you.
Thank you, Senator Sutherland. Further discussion, Senator Lowe.
Thank you, Mr. Speaker. Many of us in this room appreciate the religious and spiritual context of the Ten Commandments. What I appreciate about this bill is regardless of how you feel about the spiritual religious aspect of that document, what this bill does is it puts it in its historical context. It says there was a moral framework, a skeleton that we established our language of the Declaration of Independence and the Constitution in and around. We didn't build it around Hammurabi's Code. We didn't build it around other frameworks of law. That this was an essential guiding principle in those documents. So I would ask all of my colleagues as we look at this, not just from the perspective of religion, but from the perspective of history, it's fine to debate that history, but to completely alienate it from someone does a great injustice to those who may find some appreciation in it, regardless of the religious elements of it. So appreciate the sponsor bringing the bill and glad to support it. Thank you.
Thank you, Senator Lowe. I have Senator Ackberry and Senator Briggs. Point of order. Speaker Hale, you're recognized.
I believe Senator Rose called for the vote.
Senator Rose, did you call for the? I'm sorry, we had two more to speak. You still want to? Senator Rose?
Thank you, Mr. Speaker. I did call for the question before they were recognized, but I'll yield to you. Your call. I'm certainly willing.
Let's let these two individuals speak, and we'll wrap it up. Senator Ackberry.
Thank you, Mr. Speaker. And I walked in late, so I just wanted to clarify, because I know the Senate version was a requirement. The House version is permissive because it allows the LEA to, I guess, it allows the school to do it. It does not require the school to do it. Is that correct?
That's my understanding. Senator Briggs.
Yeah, thank you, Mr. Speaker. That's exactly what I was going to do, is call for the question, so thank you.
Senator Briggs has called for the question. Is there objection? I see none. Senator Pody to close.
Thank you, and I appreciate the discussion around this. This is one of the founding documents. We're talking about the intent of our founding fathers. Even in Congress, they authorized the printing of the Aiken Bible. There was no question that they were even putting the Bible to be read in some of the schools. So I believe this is one of the founding documents, one of the founding foundations of what our nation was built on, all three of these documents. Thank you, Mr. Speaker. I just ask for a favorable vote.
Senator Pody renews his motion. We'll be voting on House Bill 47 on third and final consideration. Those members favoring House Bill 47 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 27, 6 nays.
House Bill 47, having received a constitutional majority, I declare it passed without objection. Motion reconsidered is hereby tabled. Next order, Mr. Clerk.
Mr. Speaker, the Senate's on item number 4, Senate Bill 328 by Senator Lowe.
Senator Lowe, you're recognized on Senate Bill 328.
Thank you, Mr. Speaker. Senate Bill 328 establishes some standards around open enrollment in schools that wish to participate in the state, gives a guiding principle on posting vacancies, and allows TISA money to follow those students through that. And with that, I'll move on final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by the Senate Education Committee.
Chairman White, you're recognized on amendment number 1, education.
Thank you, Mr. Speaker. Amendment number 1 sets up a new process for open enrollment. The new process will lengthen the open enrollment period, allow parents to submit preferences for their options, set a 10-day application response window, and lists reasons for denial. Move to adopt.
Motion is to adopt, properly seconded. Discussion? Objection to the question? I see none. All in favor say aye. Opposed, nay. You adopt. On the bill, discussion. Is there objection to the question? I see none. We'll be voting on Senate Bill 328 on third and final consideration. Senator Lowe renews his motion. Those members in favor will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 30, no nays.
Senate Bill 328, having received a constitutional majority, I declare it passed without objection. Motion reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 5, Senate Bill 579 by Senator Ackberry.
Leader Ackberry, you're recognized on Senate Bill 579.
Thank you, Mr. Speaker. I move passage of Senate Bill 579 for the purpose of bringing up 2 amendments.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by the Senate Commerce and Labor Committee.
Chairman Bailey, you're recognized on amendment number 1.
Thank you, Mr. Speaker. I move Amendment 1 behind Amendment 2.
Without objection, Amendment 1 behind 2. Next amendment, Mr. Clerk.
Amendment number 2 by the Senate Commerce and Labor Committee.
Chairman Bailey, you're recognized on Commerce Amendment number 2.
Thank you, Mr. Speaker. Amendment 2 allows eligible state employees to receive up to 4 weeks of leave to recover from living organ donation surgery. I move passage and defer to the bill sponsor for further explanation.
That's a proper motion, properly seconded. Discussion. Is there objection to the question? See none. All in favor, say aye. Aye. Opposed, nay. Adopt. On the next amendment, Mr. Clerk.
Mr. Speaker, the Senate's back on amendment number 1 by the Senate Commerce and Labor Committee.
Chairman Bailey on amendment number 1, Commerce.
Thank you, Mr. Speaker. I move to withdraw.
Without objection, withdrawn. On the bill as amended, discussion. Objection to the question? See none. Senator Ackberry to close.
Thank you, Mr. Speaker and members of the Senate. This legislation as amended will allow state employees who do a living organ donation to get up to 4 weeks of leave. They average that it takes about 4 to 6 weeks to recover. The most important thing is over 100 people sacrifice themselves to donate an organ to someone on the donor list, and we just want to make that process easier for them. Thank you, Mr. Speaker.
Thank you, Senator Ackberry. Senator Ackberry renews her motion on Senate Bill 579. Those members in favor of Senate Bill 579 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote. Senator Hale, did you wish? Senator Hale votes aye.
Ayes 32, no nays.
Senate Bill 579, having received a constitutional majority, I declare it passed without objection. The motion reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 6, Senate Bill 855 by Senator Taylor.
Senator Taylor, you're recognized on Senate Bill 855.
Thank you, Mr. Speaker. I would move adoption of Senate Bill 855 for the purposes of bringing forth a committee amendment.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by the Senate Energy Committee.
Chairman Reeves, you're recognized on amendment number 1.
Thank you, Mr. Speaker. Roll amendment number 1 behind amendment number 2.
Without objection, amendment number 1 behind amendment number 2. Next amendment, Mr. Clerk.
Mr. Speaker, the Senate has amendment number 2 by the Senate Energy Committee.
Chairman Reeves, you're recognized on amendment 2.
Thank you again, Mr. Speaker. Amendment number 2 makes the bill. This amendment allows certain Tennessee municipalities that have had long-term moratoriums on new sewer connections outside their city limits to extend sewer service to nearby adjacent areas if property owners or developers pay a housing surcharge. I move the amendment and defer to the sponsor for comments and questions.
Senator Reeves moves Senate Energy Amendment number 2. It's properly seconded. Discussion. Is there objection to the question? See none. All in favor of amendment number 2 say aye. Aye. Opposed, nay. You adopt. Next amendment, Mr. Clerk.
Mr. Speaker, the Senate's back on amendment number 1 by the Senate Energy Committee.
Senator Reeves, amendment number 1.
Withdraw.
Without objection, withdrawn. On the bill as amended, discussion. Is there objection to the question? See none. Senator Taylor, you wish to close?
I renew my motion, Mr. Speaker.
Senator Taylor renews his motion for adoption of Senate Bill 855, properly seconded. Those in favor will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the Senator Massey votes aye. Mr. Clerk, take the vote.
Ayes 31, no nays.
Senate Bill 855, having received a constitutional majority, I declare it passed without objection. Motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate is on item number 7, Senate Bill 1150 by Senator Crow.
Senator Crow, you're recognized on Senate Bill 1150.
Mr. Speaker, let's put that on the last calendar if we could, please, sir. We're still waiting. There's a lot
Without
of work,
objection.
a lot of work being done in the House on that one.
Last calendar. That'll be next week, I think, Senator Crow. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 8, Senate Bill 1213 by Senator Ackberry.
Leader Ackberry, you're recognized on Senate Bill 1213.
Thank you, Mr. Speaker. I move Senate Bill 1213 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by the Senate Education Committee.
Chairman White, you're recognized on amendment number 1.
Thank you, Mr. Speaker. Changes the effective date to make the bill effective in the 26-27 school year and thereafter. Move to adopt.
That's a proper motion, properly seconded. Discussion. See none. Objection to the question. There is none. All in favor say aye. Opposed, nay. You adopt. Discussion on the bill. Is there objection to the question? Leader Ackberry to close.
Thank you, Mr. Speaker. I renew my motion.
Leader Ackberry renews her motion for adoption of Senate Bill 1213. Those in favor vote aye when the bell rings. Those opposed vote no. Let every member cast their vote when the bell rings. Powers and Massey, aye. Mr. Clerk, take the vote.
Ayes 31, 1 nay.
Senate Bill 1213, as amended, having received a constitutional majority, I declare it passed without objection. Motion reconsidered is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 9, Senate Bill 1225 by Senator Rose.
Senator Rose, you're recognized on Senate Bill 1225.
Thank you, Mr. Speaker. I move Senate Bill 1225 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Judiciary Committee Amendment.
Senator Gardenhauer, Chairman Gardenhauer, Amendment number 1.
Thank you, Mr. Speaker. Amendment 1 establishes a legal presumption that victims of human trafficking act out of a reasonable fear of death or serious injury when using force against their traffickers. It also clarifies that a person cannot be released within 12 hours after being arrested for obstructing a passageway. With that, I move Amendment number 1 for adoption and yield to the sponsor for any questions.
That's a proper motion, properly seconded. On the amendment, discussion. Senator Yarborough, on the amendment.
Thank you, Mr. Question. I'd request that we divide the question on this amendment so that we can treat Section 4 of the proposal separately.
Pardon me, you wish to divide the question?
Divide, yes, sir.
Mr. Clerk, is that divisible?
I'll need a moment to double check it.
Senator Yarborough moves to divide the question and treat Section 4 separately. Mr. Clerk.
Mr. Speaker, the amendment is divisible. Division 1 will be Section 1 of the amendment, Section 2 of the amendment, Section 3 of the amendment, and Section 5 of the amendment. Division 2 will be Section 4.
And we have to vote on the ability to divide the question. Okay, I'm advised by the clerk that it is divisible. It's a matter of right. We don't vote on it, so the motion would be to adopt Section 1, 2, 3, and 5. That would be the first motion. The second motion would be to adopt Section 4. Is that correct, Mr. Clerk? The request is to read Section 4.
Section 4 consists of division number 2, states Tennessee Code Annotated Section 40-11-123 is amended by deleting quote or obstructing the highway, end quote, and substituting instead, quote,
or obstructing a highway or other passageway, end quotes.
Okay, will be, pardon me? It'll be a voice vote on Section 1. Is there further discussion on Section 1? I see none. Voice vote, all in favor say aye. Aye. Opposed, no. Section 1 is adopted, the amendment. It's a voice vote on Section 2. Discussion. Senator Yarborough.
Thank you. I just want to clarify about the second portion that we're talking about here. I want to clarify is just the second division, which includes Section 4 of the amendment. Is that correct?
Division 2 is Section 4.
Thank you, Mr. Speaker, and members. I apologize for that little parliamentary oddity, but this legislation actually deals with a couple different things, and I could actually see members having very different opinions on the two topics. So I did not want to speak in opposition to the human trafficking statute, and want to be in support of that. The language that I do find potentially troubling, it doesn't create a new offense, but it does change a very important rule regarding the criminal procedure around someone who's arrested when protesting. This body adopted statutes that make it illegal to block highways, to block other pathways, hallways. Those things have to be proven. They have to establish, in order to be convicted of that offense, you have to have a trial where you demonstrate that you didn't have a privilege to be there. You have to demonstrate that you had the requisite intent. But what this statute does, it doesn't change any of that. It doesn't change what the underlying offense is. It just changes whether the state will mandatorily hold you for 12 hours without proof upon arrest. And that, in the current law, we only do that for highways. This would create a very large hole here that is subject to abuse depending on which type of political leadership is running a particular jurisdiction. If you can just clear out entire protests from sidewalks when they have a right to be there, and you can mandate that people be held for 12 hours, and then you don't care whether you can prove it or not, that is a huge problem. That has a massive chilling effect on free speech. And I don't know if that was the intent. I can't imagine that it would be, because I don't think that this body would want to do something that creates a path where just anybody who's protesting on a sidewalk could be arrested and held for 12 hours without any evidence, without any right to present a defense. I mean, this gets very close to just giving people the right to shut down protest at will. That is a questionable thing to do when we're talking about highways, but there's a significant safety issue there. When we're talking about, hallways or sidewalks or driveways or anything that can be used as a passageway, that's just everywhere. And creating that sort of overbreadth that allows for a mandatory 12-hour hold is something that we should just be a little bit more wary of proceeding forward on. So I would urge the members to not adopt this section of this otherwise good criminal justice bill. And so I would ask that any votes be on the board. Thank you.
Request is for on the board. We'll be voting on Division 2, which is removal of Section 4, and we'll be on the board. Senator Rose to close.
Thank you, Mr. Speaker, and I do appreciate that I think the folks on the other side of the aisle will support the First Division. I understand their concern. This was actually brought to me by a customer, a business owner in my Nashville colleague's district. And the problem was that he didn't object, or she, I actually don't know who owned the establishment. What they were objecting to was the protesters were keeping people from getting in their business, in their establishment. And that's all this is trying to do. We passed this bill in 2020 and this amends it to say you cannot block the entrance to an establishment. And I'll call for a favorable vote. Thank you.
Okay, we'll be voting on Division 2, which removes Section 4.
No, I don't.
I'm sorry. The motion is to adopt Section 4, which adopt Division 2, which is Section 4 of the bill. All those in favor will vote aye. When the bell rings, those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 27, nays 6.
Division 2 is adopted. Now we have to vote on the bill.
Bill as amended.
We're on the bill as amended. Discussion. Senator Yarborough. I'm sorry, Senator Lamar.
Thank you. I wanted to speak in favor of the section around human trafficking. I'm now confused around sections at this point. And as I reiterated in Judiciary, I really like what you're doing with this part, because when I was in the State House, I started the initial form of this part of the bill that creates an affirmative defense for human trafficking victims, and your bill took it where I really wanted it to go. So I appreciate the Senate allowing us to divide so we can vote in favor of the human trafficking, which is so important. Very passionate about that. So I appreciate you bringing this bill, and I hope everyone votes in favor of doing more to help human trafficking victims. Thank you, Mr.
Thank you, Senator Lamar. Further discussion? See none. Senator Rose, you wish to close? Senator Rose renews his motion. We'll be voting on Senate Bill 1225. Those members in favor will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote. Senate Bill 1225, having received a constitutional majority, I declare it passed. Without objection, the motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Item 10, Senate Bill 1664 by Senator Rose on third and final consideration. Mr. Speaker, the House bill is on the desk.
Senator Rose, you're recognized on Senate Bill 1664.
Move Senate Bill 1664, third and final consideration.
The House bill's here. The motion is to substitute and conform to House Bill 16 1665. It's properly seconded. Is there objection? Without objection, we're on House Bill 1665. Senator Rose moves adoption of House Bill 1665, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce and Labor Committee amendment is
Senator
in the House
Bailey,
bill.
Commerce Amendment number 1.
Thank you, Mr. Speaker. Since the amendment's in the House bill, move withdrawal.
Without objection, withdrawn. On the bill, discussion. Senator Leader Ackberry.
Thank you, Mr. Speaker. And I just rise in opposition to this legislation. I feel that having a question on a form that respects everyone's gender identity hurts no one. Honestly, you know who you are, and you just can say that. I think having the question on a form, again, most parents are the ones that fill out forms for minors anyway, so this just excludes an individual, and it's just, in my opinion, unnecessary. Thank you, Mr. Speaker.
Thank you, Senator Ackberry. Further discussion? Objection to the question? I see none. Senator Rose renews his motion. We'll be voting on House Bill 1665 on third and final consideration. Those members in favor vote aye. Opposed, vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Senator Watson votes aye. Mr. Clerk, take the vote.
Ayes 27, nays 6.
House Bill 1665, having received the constitutional majority, I declare it passed without objection. Motion reconsidered is hereby tabled. Next bill, Mr. Clerk.
Item 11, Senate Bill 1692 by Senator Massey on third and final consideration.
Chairman Massey, you're recognized on House Bill 1692.
Thank you, Mr. Speaker, and I move Senate Bill 1692 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce and Labor Committee amendment.
Chairman Bailey, you're recognized on Commerce number 1.
Thank you, Mr. Speaker. Amendment 1 enacts the Military Families Licensing Recognition Act, requiring licensing boards to recognize valid, in good standing licenses from other states for service members and their spouses who relocate due to military orders. This amendment does not override existing expedited recognition processes, but requires boards to use the fastest available method to grant licensure. It also requires certain licensing authorities to clearly notify applicants that military families may qualify for in-state license recognition. I move passage of Amendment 1 and will defer to the sponsor for further explanation.
That's a proper motion, properly seconded. Discussion? Objection to the question? I see none. All in favor of amendment number 1, say aye. Aye. Opposed, nay. You adopt. On the bill as amended, discussion. Senator Massey to close.
Thank you, Mr. Speaker. And basically, what we wanted to do is to recognize and kind of have a uniform statewide military recognition pathway. But we also wanted to be very careful to say that if we have something in place that is quicker than what we're asking for in this bill, that they would take the quickest path to do it. But we did put all the protections in place, you know, as far as background check and things like that. So with that, I renew my motion.
Senator Massey renews her motion for adoption of Senate Bill 1692. It's properly seconded. Those members in favor of Senate Bill 1692 as amended will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Senator, I guess he's out. Mr. Clerk, take the vote.
Ayes 32, no nays.
Senate Bill 1692, having received a constitutional majority, I declare it passed without objection. Motion to reconsider hereby table. Next bill, Mr. Clerk.
Speaker, on item 12, Senate Bill 1708 by Senator Taylor on third and final consideration.
Senator Taylor, you're recognized on Senate Bill 1708.
Thank you, Mr. Speaker. Before I make a motion to refer that bill back to calendar, may I be recognized for a point of personal privilege?
You may.
On my last bill, that passed 32 to 0 to 1 pass. I would just like to point out the progress that I am making with my friend and colleague from Davidson County. In committee, she voted against that bill. And over the weekend, many of you don't know, but I extended somewhat of a Oliver branch to my friend, and I believe I moved her from a no to a pass. So I just wanted to point out and make a report that I am making progress with my friend from Davidson County. So with that, Mr. Speaker, I would like to move to send Senate Bill 1708 back to calendar.
Without objection, Senate Bill 1708 is referred to the Calendar Committee. Next bill, Mr. Clerk.
Item 13, Senate Bill 1748 by Senator Bowling on third and final consideration.
Senator Bowling, you're recognized on Senate Bill 1748.
Thank you, Mr. Speaker. I move Senate Bill 1748 on third and final passage.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Transportation Safety Committee Amendment.
Chairman Massey, you're recognized on amendment number 1.
Thank you, Mr. Speaker. And the amendment requires the Commissioner of the Department of Safety to suspend a CDL if the driver is issued an out-of-service order or is unable to read and speak English. It requires an enforcement officer to issue a CDL holder an out-of-service order if the officer determines during a safety inspection that the driver is unable to read and speak English. It further instructs a CDL to remain suspended until the driver passes a written commercial test administered in English by the Department of Safety. I move the amendment and defer to the sponsor for additional comments.
Senator Massey moves Transportation Committee Amendment number 1 is properly seconded. Discussion. Is there objection to the question? Senator Yarborough.
Thank you, Mr. Speaker. Sponsor will yield.
Sponsor of the amendment or the bill?
Actually, the sponsor of the bill is fine.
Sponsor, Senator Bowling yields.
Thank you, Mr. Speaker. And I guess the first question is there any requirement, I guess, why does the issuance of the license not evaluate what we need evaluated here?
Senator Bowling to respond.
Thank you, Mr. Speaker. Many of these people have out-of-state licenses. They're driving commercial trucks, and they're coming into Tennessee.
Senator Yarborough.
Thank you, Mr. Speaker. Well, that confuses me significantly because I don't think that the Commissioner of Safety would have the authority to revoke a license that's been issued from another state. Is that the intent?
Senator Bowling to respond.
Thank you. They're not looking at the license. They're looking at the driver who's holding the license, and that driver will not be allowed to drive in Tennessee until he can speak or read, he or she can speak or read English.
Senator Yarborough.
Thank you, Mr. Speaker. So this is actually broader than what I originally thought the legislation was. So am I to take the sponsor is clarifying that if there's someone who's been issued a license from Kentucky or Missouri and they're in the state, and at a safety inspection we determine that they cannot speak English to the satisfaction of the officer who stops them, the Tennessee officer is required to seize their Kentucky license and to not let them operate under that license in Tennessee. Is that correct?
Senator Bowling to respond.
They are required to put them out of service. This is in line with federal law, and this is something that we've seen the results of not being able to speak and read English in many fatalities that have taken place across the United States with drivers, CDL drivers who have gone the wrong way on a one-way street, have not understood when to turn left. This is just basic common sense, and it's already in compliance. This will be in compliance with the federal law.
Senator Yarborough.
So that does speak to one portion of the order, but like I'm having a little trouble with the conclusion that's consistent with federal law, because other states give full faith and credit to licenses that are issued by Tennessee. And so I'm trying to understand why we would not be giving full faith and credit to licenses that are issued by other states.
Senator Bowling.
If the CDL is governed by the federal motor carrier, and I'm assuming you're a no on this legislation, and I would appreciate it if we could stop the questioning, because the questions are all going to be answered the same. This puts us in line with the federal government. This is something for safety. This will prevent many wrecks and many fatalities in the state of Tennessee.
Senator Bowling, did you move to call for the question?
Yes, sir.
And this would be on the amendment? Okay, the question's been called for. All in favor of the call for the question on the amendment, say aye. Aye. Opposed, no. The question on the amendment has been called for. All in favor of the amendment, say aye. Aye. Opposed to the amendment, say no. The amendment is adopted. On the bill as amended, discussion. Senator Yarborough.
Thank you, Mr. Speaker, and I've never had been in a situation where we're moving for question when we're still trying to get, I'm really trying to get basic information about this legislation, because I think it is pretty complicated. Because one portion of it does seem to apply to out-of-state people and has us sort of putting people who are licensed validly from other states, you know, where there's going to be an order to put them out of service, I guess. But there is a portion of this that does include Tennessee licensees. That's what's in the amendment. The commissioner shall suspend the driver's license of someone who's issued an out-of-service order. And so, I mean, so this is for, that portion is for people who have passed a commercial driver's license test in Tennessee, have been issued a valid license. And there's no requirement of what that test is. Like, it does not specify that. And there's no ability to appeal that. You can't challenge whether someone gave you sort of a ridiculous test to take, whether they just interpreted something incorrectly, whether they didn't, there's no rights or due process at all following that. You just have an automatic requirement to take another test. And I mean, this is for people for whom the CDL is their livelihood. That gives a safety inspector the ability to just kind of shut down their life without any due process. I mean, this legislation doesn't provide for any sort of appeal. It just says that if they do this, like, you have to take another test. Like, that is not the way that we typically do things in this state, or at least it's not the way that we do things anymore in the state. And the challenge here is, is pretty significant from, we actually design these tests to make sure that we're testing what is the legal requirements. This statute doesn't give that capacity, doesn't provide what the, standards would be for officers, nor are our safety officers trained or qualified to determine someone's facility with reading and writing. That is not what our safety inspectors are historically trained to do, and it's not what they should do. And I mean, sort of giving one-off safety inspections the right to effectively end someone's career and livelihood is deeply problematic. Thank you, Mr. Speaker.
Thank you. Further discussion? Objection to the question? I see none. Senator Bowling to close.
Thank you, Mr. Speaker. This legislation gives Tennessee the tools to enforce a long-standing federal safety rule, 49 CFR 393-11B2, requiring every commercial driver to read and road signs, respond to law enforcement, and complete safety documentation in English. The bill is driver-focused only, creates no employee liability. It suspends the CDL driver when a driver is found unable to meet the federal English standard, again, 49 CFR 391-11B2, or is issued a federal out-of-service order for an ELP violation. It requires the state-administered testing, not employer testing, before reinstatement. All liability is on the driver, none on the employer. Protects deaf HOH drivers who cannot speak but can read and write English and hold a federal hearing exemption. I renew my motion, Mr. Speaker.
Senator Bowling renews her motion. We'll be voting on Senate Bill 1748 on third and final consideration. Those members in favor of Senate Bill 1748 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 26, 6 nays.
Senate Bill 1748, having received a constitutional majority, I declare it passed. Without objection, the motion reconsider is hereby tabled. Next bill, Mr. Clerk. Senator Reeves, you're recognized on Senate Bill 1788.
Thank you, Mr. Speaker. I want to roll that to next Thursday.
Without objection, Thursday next. Next bill, Mr. Clerk.
Item 15, Senate Bill 1790 by Senator Reeves on third and final consideration. Mr. Speaker, the House bill is on the desk.
Senator Reeves, you're recognized on Senate Bill 1790.
Yeah, Mr. Speaker, I want to conform and substitute to House Bill 1741.
The motion is to conform and substitute to House Bill 1741. Is there objection? I see none. Without objection, we're on House Bill 1741. Senator Reeves moves adoption of House Bill 1741. It's properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce and Labor Committee amendment is in the House bill.
Chairman Bailey, you're recognized on Amendment 1.
Thank you, Mr. Speaker. Amendment 1 is in the House bill. Moved withdrawal.
Without objection, withdrawn. On the bill, on the House bill, discussion. Objection to the question, I see none. We'll be voting on House Bill 1741 on third and final consideration. Those members in favor of House Bill 1741 vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 28, no nays.
House Bill 1741, having received the constitutional majority, I declare it passed. Without objection, the motion reconsider is hereby tabled. Next bill, Mr. Clerk.
Item 16, Senate Bill 1800 by Senator Lamar on third and final consideration.
Senator Lamar, you're recognized on Senate Bill 1800.
Thank you, Mr. Speaker. This bill is still being worked out in the House because my House sponsor was absent, and they're trying to open it back up so he has a chance to present. So just let us, can I motion to let it sit in calendar until it can be heard in the House?
Without objection, calendar committee. Next bill, Mr. Clerk.
Item 17, Senate Bill 1828 by Senator Rose on third and final consideration.
Senator Rose, you're recognized on Senate Bill 1828.
Thank you, Mr. Speaker. What this bill does, it specifies that local education agencies, public charter schools, public school teachers, and faculty or other instructors employed at public institutions of higher education may provide instruction on the positive impacts of religion on American history whenever instruction in American history is being provided. That's what the bill does. Thank you, Mr. Speaker, and ask for a positive vote. Be glad to try to answer any questions.
Amendments, Mr. Clerk.
Amendment number 1, Senate Education Committee amendment.
Chairman White, you're recognized on Amendment 1.
Thank you, Mr. Speaker. Amendment 1 clarifies that instructions on the role of religion in various events in American history does not violate the First Amendment, grants permission to LEAs and universities to provide instruction on the positive contribution religion made in American history, and provides a list of American historical events where such instruction may be included. Move to adopt.
Motion is to adopt, properly seconded. Discussion. Objection to the question? I see none. All in favor of amendment number 1 say aye. Aye. Opposed, no. The amendment's passed. On the bill as amended, discussion. Is there objection to the question? Senator Crow.
Mr. Speaker, this is a great bill. I co-sponsored it with Senator Rose. We had the Turning Point kids come to Nashville, and we had lunch with them and talked to them. What an amazing group of young people these are. And all this does is make sure that when we teach American history, am I on the right bill, Senator Rose? I'm on the right bill, right? When we teach American history, that we make sure that our kids understand the role that religion and faith had to do with that history. A great story that I told the kids was, when George Washington was taking his first oath of office, he raised his hand. They couldn't find a Bible. I think they found a Bible at the one of the Masonic lodges, and they brought it in, and he held his hand up. And back then, the oath of office that he took and that we take now, with the exception of what he added, came straight from the Constitution. And so he raised his hand and said the words, and he added 4 words. Senator Rose, you know what those words are? So help me God. And just, there's some great stories like that, just to instill in our young people how important faith was in the construction of this America that we love. Thank you, Mr. Chair.
Thank you, Senator Crow. Leader Ackberry.
Thank you, Mr. Speaker. And I said some of these points in committee, but the schools are already allowed to teach history and the impact of religion on history and the place that religion has in history. My concern with this, and I say this as a Christian, is that it specifies the positive impacts of religion, which is not a balanced view of history. You have to show positive and negative. So when we talk about different parts of history, the civil rights movement, slavery, things like that, there are negative aspects of how religion was used, how Bible verses were used to justify segregation, how Bible verses were used to justify slavery. So if we're not teaching it as a sense of religion and the reason why people should become Christians, if we're teaching it as a whole history, we shouldn't specify that we can only teach the positive impacts, because history is positive and negative. And in order to have a whole presentation of it, you have to cover both. Thank you, Mr. Speaker.
Thank you, Leader Ackberry. Chairman Lamar.
Thank you, Mr. Speaker. Not only do I second the comments of my leader, but I guess I also just had a little bit of concern, and God rest his soul, Lord knows I don't agree with anything that has happened to this young man, but the fact that we are naming it the Charlie Kirk American Heritage Act, my issue of concern is not rather, about what the circumstances surrounding his untimely death, but more so that if we're talking about American heritage in a way that is about uniting our country, much of the things he talked about was so divisive. He made very negative comments about the civil rights movement, African Americans, women, and all other groups. And our school system, our public school system, has a diversity of types of background, people, demographic, races, religions, and all other sorts of demographics. And I just think it's disingenuous to name a Heritage Act around American history around someone who was very divisive around American history, and it promoted so many negative rhetoric around people in society. I know what happened to him was unfortunate, and we all want that person to be held accountable, but I just don't think that naming this particular act after him to teach some of these particular competencies which he spoke falsely around some of the things regarding these competencies and around many people in our country, including people like myself. I've had grave concern, and which is why I would have to vote against it. Thank you.
Thank you, Senator Lamar. Senator Yarborough.
Thank you, Mr. Speaker, and I'm sure I agree with some of the concerns that were raised here, and there are whatever legal issues, but I don't really care about that. I guess I really just fundamentally disagree with what this says about Christianity. I believe in like service to the church is ministry and service. It is not dominion. It is not power. Like I believe in a Savior who was like born in a manger in a when there's no room in the inn, not one that's used to clothe like the power of the state. And I have no desire. I think people mistake what separation of church and state's about a lot of times. I think there are a lot of people perhaps on the left that do think you're trying to protect the state from the church. But I actually think a lot of this is about trying to protect the church from the state. And believers should have a real hesitation before our faith is used as an instrument to endorse the goings on of a certain politics or certain political systems or certain ideologies. Faith has traditionally been more eternal and more universal than that. And the faith that and so, I think what we're doing is we're endorsing not a Christian version of America, we're endorsing a version of Christianity that's more about empire than it is about Jesus. And I just fundamentally disagree with it.
Thank you, Senator Yarborough. Further discussion? I see none. Senator Rose to close.
Thank you, Mr. Speaker, and I do appreciate some of the remarks that were made. I would just say a couple of things. I was asked during committee, why are we doing this? Because there's really been confusion about what was meant by separation of church and state. And I could go on for a long while, but I'll just say a few things. Even Thomas Jefferson, who has been proclaimed a deist, made it a point to go to church every Sunday. It didn't matter what the weather was like. He recognized the influence of our Judeo-Christian heritage. A couple of things I'd like to share, Mr. Speaker, and then I'll close. The iconic Washington Monument towers 555 feet above in our nation's capital, and right on the top of that is an aluminum cap that says Laus Deo, praise be to God. It's documented that schools now are Ivy League universities were established in early the 18th century. Princeton, Harvard, Columbia, Yale, they were seminaries. They were Christian seminaries. I'll leave it there. Of the 56 signers of the Declaration of Independence, 29 were graduates of one of those seminaries. 11 of the original 13 states' constitutions specifically required members serving in their general assemblies to proclaim their faith in Jesus Christ. And I could go on and on and on, but I'll just say this. I'm proud of a nation and some of the issues that have been raised by my colleagues on the other side of the aisle, because of who we are, we have course corrected many of those. There's more to do. But I'm thankful that we saw there were injustices that were created on our peoples through our history, and we've corrected them. Mr. Speaker, I renew my motion and ask for a positive vote. Thank you.
Senator Rose renews his motion on Senate Bill 1828. It's properly seconded. All those in favor vote aye when the bell rings. Those opposed to vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 27, nays 6.
Senate Bill 1828, having received a constitutional majority, I declare it passed without objection. Motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Item 18, Senate Bill 1858 by Senator Stevens on third and final consideration.
Senator Stevens, you're recognized on Senate Bill 1858.
Thank you, Mr. Speaker. For purposes of bringing up an amendment which makes the bill, I'll move Senate Bill 1858 on third and final consideration.
Senator Stevens moves adoption of Senate Bill 1858. It's properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Judiciary Committee Amendment.
Senate Judiciary, Chairman Gardner.
Thank you, Mr. Speaker. Amendment 1 changes the venue for 3-judge panel cases to the venue where the state resides and allows the Supreme Court to select all 3 judges. It also increases the minimum time a court must give the General Assembly to remedy any defects in a redistricting plan from 15 to 90 days. With that, I move Amendment 1 for adoption and yield to the sponsor for any question.
That's a proper motion, properly seconded. Discussion on amendment number 1. Is there objection to the Senator Yarborough?
Thank you. Thank you. And the sponsor of the bill would yield.
Senator Stevens, the questions.
So what's the significant change in terms of what's the current law and what's this change?
Senator Stevens to respond.
Thank you, Mr. Speaker. Current law for, well, I'll start with the most obvious one. Current law for a redistricting plan limits the General Assembly to only having 15 days to make any change. Obviously, 90 days gives us more time. It'd be nearly impossible to get a new plan in place in just 15 days. In 2021, we had established the 3-judge panel case. Originally, as current law is, that would allow the plaintiff to choose the venue, which is fairly abnormal in the law. Usually it's where a defendant resides. So this, because the state would be the defendant in these cases, challenging the constitutionality of a statute, that we're just going to make it, the venue would be where the state resides, which would be in any county or district within the state. Also, the change would be, so if you picked, let's say, Carroll County to challenge a statute, right now it would be the Carroll County Chancellor plus a judge from the middle and eastern divisions. What this would do is simply allow the Supreme Court to appoint all 3 judges that would hear the case. This allows more flexibility in these cases, preventing burdening judges with these often very difficult cases to manage, and just gives more flexibility, like I said, for docket management to the Supreme Court.
Senator Yarborough.
Thank you, Mr. Speaker. I just want to note one caution. I mean, when the requirement of, I think that trying to force the timing issue like we are here and provide more time actually could end up backfiring on the courts, on the legislature, in terms of when the court needs to make decisions to remedy constitutional errors in a period that takes a shorter amount of time. They will just issue an order themselves by redrawing rather than sending it back to this body because it can't be done in a more timely way. But I guess the other problem here is the decision to pull out this one set of cases and treat it differently than any other constitutional litigation doesn't make any sense. And I mean, for instance, the example that was just given, if someone who's a plaintiff in Carroll County wanted to challenge the lines in Carroll County and they sued in Carroll County, then the Supreme Court, I mean, could, under this statute, make them drive to Memphis for every court appearance. I don't know why we would, for this set of litigation, create a situation where the plaintiffs are treated more disfavorably than the plaintiffs in other litigation. So I just think we're creating like a class of one in terms of constitutional things, and a class that's designed to not provide the same access to courts that we provide for constitutional challenges generally.
Further discussion. Senator Stevens to close.
Thank you, Mr. Speaker. I renew my motion.
Senator Stevens renews his motion for passage on Senate Bill 1858. I'm sorry, we're on the amendment. All in favor of the amendment, say aye. Aye. Opposed, nay. You adopt the amendment. On the bill as amended, discussion. Senator Campbell.
Thank you, Mr. Speaker. A question for the sponsor, if the sponsor yield.
Sponsor yields.
Just one question. Does the sponsor believe that courts should be neutral arbiters in redistricting cases? And if so, how does this preserve that neutrality?
Senator Stevens to respond.
Thank you, Mr. Speaker. Of course, courts are neutral arbiters, and it's more about the ability and the docket management rather than a plaintiff dictating which court they would like to hear it. It allows the courts to manage those dockets so that a court that has the time and the experience to be able to deal with it, perhaps where a plaintiff decides they want to file the case, may not match with the ability of the court to handle it. They may have large matters going on. They may be behind in their docket. So it's really just docket management.
Further discussion. Objection to the question? See none. We'll be voting on Senate Bill 1858 as amended on third and final consideration. Those members in favor of Senate Bill 1858 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 27, nays 6.
Senate Bill 1858, having received a constitutional majority, I declare it passed without objection. The motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Item 19, Senate Bill 1880 by Senator Johnson on third and final consideration.
Leader Johnson, you're recognized on Senate Bill 1880.
You'll do Senator Roberts.
Senator Roberts, you're recognized.
Thank you, Mr. Speaker. I move Senate Bill 1880 on third and final consideration.
It's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Government Operations Committee Amendment.
Senator Jackson, Government Op, Amendment number 1.
Thank you, Mr. Speaker. And the House amendment clarifies that the Tennessee Sports Hall of Fame Board must elect a chair, a vice chair, other necessary officers, and the executive committee at the first meeting every 2 years rather than annually, and move to concur.
You've heard. This is on Homeland Security.
Wrong one. This Senate Bill 1880, Amendment 1 rewrites the bill and creates the Office of Homeland Security within the Department of Safety. Mr. Speaker, I move Amendment 1 and yield to the sponsor for the question.
Senator Jackson moves amendment number 1. It's properly seconded. Discussion. Is there objection to the question? I see none. All in favor of amendment number 1 say aye. Aye. Opposed, nay. You adopt amendment number 1. On the bill as amended, discussion. Is there objection to the question? See none. We'll be voting on Senator Roberts renews his motion. We'll be voting on Senate Bill 1880 on third and final consideration. Those members in favor Senate Bill 1880 will vote aye when the bell rings. Those opposed to vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 25, nays 6.
Senate Bill 1880, having received a constitutional majority, I declare it passed without objection. The motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Item 20, Senate Bill 1883 by Senator Hatcher on third and final consideration.
Senator Hatcher, you're recognized on Senate Bill 1883.
Thank you, Mr. Speaker. I move Senate Bill 1883 on third and final consideration.
That's a proper motion, properly seconded. Amendments, I'm sorry, there are no amendments. On the bills, if you could give us an explanation.
Thank you, sir. This is an administration bill. The legislation aligns TDEC statutes governing administration appeals with the Uniform Administrative Procedures Act. It changes four things. Amends the time for administrative judges to issue initial orders in department contested case hearings from 60 days to 90 days. Amends the time to appeal an initial order from 30 days to 15 days. Eliminates the opportunity for boards to vote to review an initial order when no party appeals, and provides for hazardous waste appeals to be heard in the department's environmental field office region where the site or facility is located rather than in the county, because TDEC does not have offices in every county. That is an explanation, Mr. Speaker.
Thank you, Senator Hatcher. Discussion on the bill. Objection to the question? I see none. Senator Hatcher renews his motion. We'll be voting on Senate Bill 1883 on third and final consideration. Those members in favor of Senate Bill 1883, vote aye when the bell rings. Those opposed to vote no. Let every member cast their vote when the bell rings. Has every member voted? Senator Gardenhauer votes aye. Mr. Clerk, take the vote.
Ayes 27, nays 6.
Senate Bill 1883, having received a constitutional majority, I declare it passed without objection. The motion to reconsider is hereby tabled. Thank you. Next bill, Mr. Clerk.
Item 21, Senate Bill 1927 by Senator Massey on third and final consideration.
Senator Massey, you're recognized on Senate Bill 1927.
Thank you, Mr. Speaker, and I move that back to calendar.
Without objection, back to the calendar committee. Next bill, Mr. Clerk.
Item 22, Senate Bill 2273 by Senator Briggs on third and final consideration.
Senator Briggs, you're recognized on Senate Bill 2273.
Thank you very much, Mr. Speaker. This bill has to do with subdivisions and developments that may be around golf courses, swimming pools, or other amenities. In the properties, when they're sold in the covenants, there is clauses that say the fees to maintain those facilities still must be paid. What this bill does, it affirms the fact that the amenities are part of the covenants of these of a home when it's sold and all, and that the owners of the home will be obligated to pay those to maintain the facilities. That's the bill, and I would like to move it on third and final consideration.
Senator Briggs moves the bill on third and final consideration. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce and Labor Committee Amendment.
Commerce and Labor, Chairman Bailey.
Thank you, Mr. Speaker. Amendment 1 clarifies current law so it's clear contracts where buyers pay a home and a club membership fee are valid and enforceable. This amendment does not create any new fees. I move passage of Amendment 1. Defer to the sponsor for further explanation.
Motion is for passage of Commerce Committee Amendment number 1. It's properly seconded. Discussion. Objection to the question? I see none. All in favor say aye. Opposed, nay. You adopt. Senator Briggs, on the bill discussion. Is there objection to the question? I see none. Senator Briggs renews his motion. We'll be voting on Senate Bill 2273 on third and final consideration. Those members favoring Senate Bill 2273 vote aye when the bell rings. Those opposed vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 32, no nays.
Senate Bill 2273, having received the Constitution majority, I declare it passed without objection. The motion reconsider is hereby tabled. Next bill, Mr. Clerk.
Item 23, Senate Bill 2286 by Senator Lamar on third and final consideration.
Senator Lamar, you're recognized on Senate Bill 2286.
Thank you, Mr. Speaker. I would like to move Senate Bill 2286 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce and Labor Committee amendment.
Chairman Bailey, you're recognized on amendment number 1.
Thank you, Mr. Speaker. Amendment 1 directs the Commissioner of the Department of Health to study neighboring states to assess the levels of practice independence for certified nurse midwives. I move passage of Amendment 1 and defer to the sponsor for further explanation.
That's a proper motion, properly seconded. Discussion on Amendment 1. Objection to the question? I see none. All in favor of Amendment number 1, say aye. Opposed, nay. You adopt Amendment number 1 on the bill as amended. Discussion. Is there objection to the question? See none. Senator Lamar renews her motion. We'll be voting on Senate Bill 2286 on third and final consideration. Those members in favor of Senate Bill 2286 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Senator Hatcher votes aye. Mr. Clerk, take the vote.
Ayes 32, no nays.
Senate Bill 2286, having received a Constitution majority, I declare it passed without objection. The motion reconsidered hereby tabled. Next bill, Mr. Clerk.
Item 24, Senate Bill 2336 by Senator Gardenhire on third and final consideration.
Chairman Gardenhire, you're recognized on Senate Bill 2336.
Thank you, Mr. Speaker. I move Senate Bill 2336 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce Labor Committee amendment.
Senator Bailey, you're recognized on Amendment 1, Commerce.
Thank you, Mr. Speaker. Amendment 1 removes the requirement for an applicant seeking employment with a public, private, or volunteer fire agency to submit a fingerprint-based background check conducted by the Tennessee Bureau of Investigation, the Federal Bureau of Investigation, another law enforcement agency, or another legally authorized entity. I move passage of Amendment 1 and will defer to the sponsor for further explanation.
That's a proper motion, properly seconded. Discussion on Amendment 1. Objection to the question? I see none. All in favor of Amendment number 1, say aye. Opposed, no. You adopt. On the bill as amended, discussion. Is there objection to the question? See none. Senator Gardenhire to close.
Thank you, Mr. Speaker. I renew the motion. I think the chairman have described the amendment that makes the bill properly. Thank you.
Senator Gardenhire renews his motion for passage on Senate Bill 2336 as amended. Those members in favor vote aye when the bell rings. Those opposed vote no. Let every member cast their vote when the bell rings. Has every member voted? Senator Ackberry votes aye. Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 33, no nays.
Senate Bill 2336, having received the constitutional majority, I declare it passed without objection. The motion reconsidered is hereby tabled. Next bill, Mr. Clerk.
Item 25, Senate Bill 2424 by Senator Crowe on third and final consideration.
Senator Crowe, you're recognized on Senate Bill 2424.
Thank you, Mr. Chair. If I could move this bill on third and final consideration, please, sir.
Senator Crowe moves adoption on third and final consideration of Senate Bill 2424. Properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Commerce and Labor Committee amendment.
Chairman Bailey, amendment number 1.
Thank you, Mr. Speaker. Amendment 1 creates the Senator Frank Nicely National Security and Economic Protection Act, which expands existing restrictions on foreign land ownership, adds prohibited foreign parties, or PFPs, to the list of foreign-controlled entities barred from acquiring interest in non-agriculture land in the state, and prohibits anyone from holding such land as an agent, trustee, or fiduciary on behalf of a PFP. It requires PFPs that hold an interest in non-agriculture land after January 1 of 2025 to register with the Secretary of State. I move passage of Amendment 1 and defer to the bill sponsor for further explanation.
Senator Bailey moves passage, properly seconded. Discussion. Is there objection to the question? I see none. All in favor say aye. Aye. Opposed, nay. You adopt. On the bill as amended, discussion. Senator Sutherland?
No, sir.
Okay. I see none. Objection to the question. There is none. Senator Crow to close.
Thank you, Mr. Speaker. I just renew my motion, please, sir.
Senator Crow renews his motion on Senate Bill 2424. Those members in favor of Senate Bill 2424 as amended will vote aye when the bell rings. Those opposed will vote no, and let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 32, no nays.
Senator Powers votes aye. Senate Bill 2424, having received the constitutional majority, I declare it passed without objection. To reconsider, goes to the table. Next bill, Mr. Clerk.
Item 26, Senate Bill 2441 by Senator Powers.
Senator Powers, you're recognized on Senate Bill 2441.
Thank you, Mr. Speaker. I move Senate Bill 2441 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1, Senate Education Committee amendment.
Chairman White, you're recognized on amendment number 1.
Thank you, Mr. Speaker. Amendment number 1 will require virtual schools that are identified as a priority school or have significant below expectation TVOS scores for any 3 consecutive years to be closed. Additionally, the amendment contains parental notification requirements that a school is subject to closure or is in danger of meeting closure requirements, and the Department of Education to maintain a list of virtual school operators whose schools have been subject to closure on the department's website. Move to adopt.
Senator White moves adoption of Education Committee Amendment number 1. It's properly seconded. Discussion. Is there objection to the question? See none. All in favor of amendment number 1 say aye. Opposed, nay. You adopt. Amendment number 1 on the bill as amended. Discussion. Senator Briggs.
Yeah, thank you very much, Mr. Speaker. I think some of us that were here a decade or so ago, we had this, it's deja vu all over again. We had this same discussion then, and it was a very lively discussion on whether to keep these, some of these virtual schools open or to close them. I know at the time the administration was pushing very hard to close some of those. It was a very close vote, very lively discussion, and the legislature voted to go ahead and close the underperforming schools. The courts came back and said that, well, the data was a year old. They also said that there wasn't the capacity to absorb some of the students that would be in the closed virtual schools. And they said, let's give it a year or two to see if they improve. It's now been at least a decade, maybe even 11 years since then. We've kicked the can down the road now for 10, 11, or 12 years. There is capacity, from what I understand, in the other schools that are doing very well, quite frankly. And I am going to stand in support of this bill. I think we've been patient. I think we've waited long enough. I think waiting another year is not going to solve a problem that's been going on for 10 years, and we have much better schools, much better virtual schools that these children can transfer into.
Further discussion, Senator Hatcher.
Thank you, Mr. Speaker. I have one question. The virtual school students, do they get the same amount of money as the public school kids do?
Senator Powers to respond.
That is correct. They get the same TISA money, the $7,300 plus any add-ons.
Senator Hatcher.
Have you got a final number of how much money that would be with the virtual schools that we're talking about?
Senator Powers
On the
to
bill.
respond.
I will speak on that when I speak to the bill.
Okay.
If that's okay. If that's okay.
Thank you, Senator Hatcher. Further discussions? Senator Hensley.
Thank you, Mr. Speaker, and certainly I'm not opposed to the schools closing if they're not meeting the standards, but I think some of these schools need some more time. They haven't all been open several years, and certainly some of them, one of them especially, has been a priority list for 13 years, and they've certainly had time. But some of them haven't been open that long. I think we should let them, the ones that haven't been open very long, have some more time to correct their deficiencies. But thank you, Mr. Speaker.
Thank you, Senator Hensley. Further discussion? Senator Ackberry.
Thank you, Mr. Speaker. And I rise in support of this bill. And the reason for that is really simple. Children need options with virtual schools. It does provide care for not necessarily the traditional student. And it would be different if we were asking them and holding them to a certain standard related to achievement. This is specifically talking about growth. The children in those virtual schools deserve to be taught in a way where they can grow, just like children who are in brick and mortar schools. And so that's why I support this. We've been talking about virtual schools. I was a House member. I've been a Senate member since 2019 now. They have to be held to a standard that provides the correct education for the tax dollars that they're receiving. And the children who go there, if they are already more vulnerable or need additional assistance, they deserve to be able to have growth so that they can, change the trajectory of their life. So to me, it's not complicated. It's not like we're saying you have no other option. There are thousands of other seats available where these children can attend. So thank you, Mr. Speaker. Thank you, Mr. Sponsor.
Thank you, Senator Ackberry. Further discussion? Objection to the question? I see none. Senator Powers to close.
Thank you, Mr. Speaker.
I'm sorry, Senator Gardenhauer.
Thank you, Mr. Speaker. I would remind the sponsor and the rest of the members of this body that the students that go to these virtual schools have no other choice. They come from other counties to attend these virtual schools because they couldn't, for one reason or another, couldn't adjust to the normal public schools. And to close a virtual school that is failing, I agree with one of my colleagues, we're going to set a precedent. If we vote to close these schools, we have to have the fortitude, to close these other failing schools, no matter where they are. And if we don't have that ability to make that decision, then why pick on these schools and these students that have no other choice? I'll be voting against this bill. I understand where the sponsor is coming from, but these students have no other choice. They've already made the choice. Thank you, Mr. Speaker.
Thank you, Senator Gardenhauer. Further discussion? Objection to the question? Senator Powers to close.
Thank you, Mr. Speaker. I somehow missed my chance to speak, but I do want to speak on this bill. In 2011, the state of Tennessee created public virtual schools for students. Today, we have 65 such schools, with 12 being level 1 being the worst out of 5 different levels. With this bill, these 12 schools would be closed and the students would be shifted to other much higher performing virtual schools. I am assured that we have the bandwidth and there's room for all these students that are displaced. I am further told that we would be able to set up some sort of a hotline to get these students re-enrolled in another higher performing school. Members, the only change that we're making here to Tennessee Code for this bill is changing may to shall. We all know that that can have large implications. On this particular bill, it will state that the commissioner, it's going from the commissioner may close the virtual school to the commissioner shall close the virtual schools. Today we have 12 schools that would fit into that category. That is 18% of the schools. Over the last 12, 13 years, Senator Briggs, is how long it's been. You get closed for achievement growth significantly below expectations for 3 consecutive years. In the case of the largest school that we have, largest virtual school we have in Tennessee, they have 1,800, almost 1,900 students, and they're performing well below, they're level 1. So let's follow the money here. There's 8,163 students in level 1, 8,163 students. Multiply that by 7,300, which is the base model, the base for the TISA, 7,300. You get $59 million. So I would ask you, what happens if we put this off for a year? I would surmise that we're going to lose another damn near $60 million by putting this off for a year. Put it off for 3 years, $180 million. And what do we get for that? Nothing. These 12 schools have no growth. They test them at the end. We know what's happening. There is no growth coming out of these schools. Yet, we're spending $60 million a year. How long are we going to let that go on? Following the money, let's also say that, let's look at some of these schools. They don't have buildings. They don't have furniture. They don't pay utilities. They don't have a cafeteria. There's no sports facilities. There's no buses. There's no bus drivers. They don't have a nurse. They don't have a janitors. Mr. Speaker, they don't even have a bathroom. The largest virtual school has been a level 1 for 13 years. Students here have seen little to no academic growth. And for 13 years, I guess, no one cared about those students. But today, members, we have a chance to change the narrative and the lives of virtual students across the state of Tennessee. Please help me in passing Senate Bill 2441.
Thank you, Senator Powers. Senator Powers renews his motion for passage of Senate Bill 2441 as amended on third and final consideration. Those members in favor of Senate Bill 2441 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 26, 6 nays.
Senate Bill 2441 is amended. Having received a constitutional majority, I declare it passed. Without objection, the motion reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 27, Senate Bill 2459 by Senator Bailey.
Senator Bailey, you're recognized on Senate Bill 2459.
Thank you, Mr. Speaker. For the purposes of bringing up an amendment, I will move Senate Bill 2459 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by the Senate Judiciary Committee.
Senator Gardenhauer, amendment number 1, Judiciary.
Thank you, Mr. Speaker. Amendment 1 prohibits the Department of Children's Services from requesting, identifying details, quantities, and types of firearms and ammunition owned by foster parents. The department may still inquire about the presence of weapons in the home and inspect their storage area to ensure they are secure. These restrictions do not apply if the department is conducting a formal investigation into allegations of child abuse or neglect within the home. With that, I move Amendment 1 for adoption and yield to the sponsor for any additional questions.
Amendment number 1 has been properly moved and seconded. Discussion on amendment number 1. Is there objection to the question? Senator Campbell, are you on the bill? All those in favor of amendment number 1 say aye. Aye. Opposed, nay. You adopt amendment number 1 on the bill as amended. Discussion. Senator Campbell.
Thank you, Mr. Speaker. Will the sponsor yield?
Sponsor yields.
So to the sponsor, is it correct that under this bill, DCS can no longer verify how firearms are stored beyond a visual check? So that means they can't confirm whether a weapon is actually secured or accessible to a child?
Senator Bailey to respond.
Thank you, Mr. Speaker. This bill simply states that the department cannot go in and demand that those weapons be shown if requested by a caseworker with DCS.
Senator Campbell.
Thank you, Mr. Speaker. So this concerns me because if a child's harmed due to an improperly stored weapon that DCS was prohibited from fully inspecting, I think that we can say as our job as stewards of these children's safety, that does not make these children safer in any way. And I'm not sure why we would be limiting DCS's ability to make sure that our children are safe. And so I will be voting against this bill. Thank you, Mr. Speaker.
Thank you, Senator Campbell. Further discussion, Chairman Lamar.
Thank you, Mr. Speaker. I have a question for the sponsor.
Sponsor yields.
Thank you. If there is a DCS child who has a background of disciplinary actions or issues regarding firearms or gun charges or any sort of gun-related issues, is DCS also not to inquire about the potential foster parents' guns they have in the house based on the fact that that child already has had prior issues regarding guns? I hope I explained that correctly.
Senator,
or ask that, sorry.
Chairman Bailey to respond.
Thank you, Mr. Speaker. I just want to be clear to everyone, this does not keep the department from asking a foster family if they have firearms and ammunition inside the home. That foster family would still have to comply with that request stating that they have firearms and ammunition in the home and that those firearms and ammunition are safely stored.
Senator Lamar to respond.
Thank you to the sponsor. Thank you, Mr. Speaker.
Further discussion? Objection to the question? See none. We'll be voting on Senate Bill 2459 on third and final consideration. Those members in favor of Senate Bill 2459 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 27, 5 nays.
Senator Powers votes aye. Senate Bill 2459, having received a constitutional majority, I declare it passed. Without objection, motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 28, Senate Bill 2585 by Senator Jackson.
Senator Jackson, you're recognized on Senate Bill 2585.
Thank you, Mr. Speaker, and I move for the third and final consideration, Senate Bill 2585.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by the Commerce and Labor Committee.
Senator Bailey, Chairman Bailey, you're recognized on amendment number 1, Commerce.
Thank you, Mr. Speaker. Amendment 1 renames the board for professional counselors, marital and family therapists, and clinical pastoral therapist, and redesignates licensed marital and family therapists as licensed marriage and family therapists, requires licensure by endorsement for qualified out-of-state therapists, allows students, interns, and supervised individuals to use specified professional titles including intern, student therapist, and pre-licensed marriage and family therapist. It authorizes approved supervisors to use the LMFTS designation and requires them to complete 6 hours of supervised related education continuing every 2 years, including at least 3 hours in ethics and state law. I move passage of Amendment 1 and definitely defer to the sponsor for further explanation.
Senator Bailey moves passage of Amendment number 1, properly seconded. Discussion? Objection to the question? I see none. All in favor of Amendment number 1 say aye. Aye. Opposed, nay. You adopt. On the bill as amended, discussion. Is there objection to the question? I see none. Senator Jackson renews his motion for passage of Senate Bill 2585. Those members in favor of Senate Bill 2585 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Senator Lowe votes aye. Senator Powers votes aye. Mr. Clerk, take the vote.
Ayes 32, no nays.
Senate Bill 2585, having received the constitutional majority, I declare it passed without objection. The motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 29, Senate Bill 2642 by Senator Roberts.
Senator Roberts, you are recognized on Senate Bill 2642.
Thank you, Mr. Speaker. I move Senate Bill 2642 on third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by Senate Commerce and Labor Committee.
Chairman Bailey, amendment number 1.
Thank you, Mr. Speaker. Amendment 1 requires property holders to make reasonable efforts to notify charitable organizations named as beneficiaries that they may have a claim and provide contact information. Allows charities to submit an affidavit and documents to claim property or request information while prohibiting holders from requiring extra personal information, background checks, specific bank accounts, or co-beneficiary claims. If requirements are met, the property must be transferred to the charity, provides liability protection for holders acting in good faith, and requires recipients of such requests to verify the charity's authority within 30 days. Allows charities to take legal action if property or information is not provided within 30 days, with potential recovery of damages, costs, and attorney's fees. Excludes insurance policies, annuities, and similar regulated products from the Act. I move passage of Amendment 1 and defer to the sponsor for further explanation.
That's a proper motion, properly seconded. Discussion on Amendment 1. Objection to the question? I see none. All in favor of Amendment number 1 by the Commerce Committee will say aye. Opposed, nay. You adopt Amendment number 1. On the bill as amended, discussion. Is there objection to the question? I see none. Senator Roberts renews his motion. We'll be voting on Senate Bill 2642 on third and final consideration. Those members in favor of Senate Bill 2642 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Senator Massey votes aye. Senator Powers votes aye. Mr. Clerk, take the vote.
Ayes 33, no nays.
Senate Bill 2642, having received the constitutional majority, I declare it passed without objection. The motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 30, Senate Bill 1469 by Senator Wally.
Senator Wally, you're recognized on Senate Bill 1469.
Mr. Speaker, thank you very much. Mr. Speaker, for the purposes of calling up an amendment which make the bill, I'd move you, sir, passage of Senate Bill 1469 on third and final consideration.
Senator Wiley moves passage of Senate Bill 1469. Amendments, Mr. Clerk.
Amendment number 1 by the Senate Judiciary Committee.
Chairman Gardner, amendment number 1.
Thank you, Mr. Speaker. Amendment 1 raises financial requirements for a minor to be considered a content creator and removes the bill's prohibition and penalties regarding children under the age of 14. It also adds new legal protections for minors featured on the online content and requires social media platforms to implement strategies to prevent sexualization and exploitation of minors on their services. With that, I move amendment number 1 for adoption and yield to the sponsor for any additional questions.
That's a proper motion, properly seconded. Discussion on amendment 1. Senator Lamar on amendment 1.
I'll wait till the sponsor.
Objection to the question? I see none. All in favor of amendment number 1, say aye. Aye. Those opposed, nay. You adopt. On the bill as amended, Senator Lamar.
Thank you, Mr. Speaker. Will the sponsor yield for questions?
Sponsor yields. Senator Wally.
If I might have an opportunity to explain the bill first, then I'd be glad to yield for a question on the bill.
You're recognized to explain the bill.
Thank you very much, Mr. Speaker. Members, this legislation, as amended, recognizes that the digital economy that we live in has created new forms of work involving children, and our laws should evolve to ensure that those children are treated fairly and protected from exploitation. This bill, as amended, Mr. Speaker, will update our Tennessee law to address an issue that simply didn't exist when most of our child labor protections were written. That is the rise of monetized social media content featuring children. Across the country and here in Tennessee, legislatures and families are creating online video content that generates significant income through advertising, sponsorships, and platform monetization. In many cases, children are a central part of that content, and in effect, are contributing to the work that produces the income. This bill ensures that when a child meaningfully participates in monetized online content, that child receives basic protections similar to those long provided on child performers in our traditional media. First, the bill clearly defines that modern digital environment. It establishes that qualifies as content creation, online platforms, and compensated video content, while making sure that services like email, broadband, cloud storage, and standard e-commerce platforms are not unintentionally regulated. Second, the bill sets reasonable thresholds for the law applying to minors considered engaged in content creation. And that's only when 3 conditions are met, Mr. Speaker. The child appears in at least 30% of the compensated content. The content is actually generating revenue through views or monetization, and the creator earns at least $15,000 annually from that content. It ensures that law applies only to commercialized content operations, not to families casually posting videos online. And third, the amendment provides financial protection for minors when a child is a significant part of that monetized content. A portion of those earnings are tied to the child's appearance and is to be placed in a protected trust account for the child's benefit, consistent with the Tennessee Uniform Transfer to Minors Act. Mr. Speaker, importantly, it also provides young people with control over their digital identity. A minor age 14 or older, or an adult who appeared in monetized content as a child, can request that content featuring their likeness is removed from the platform. And finally, Mr. Speaker, the amendment includes provisions aimed at preventing the financial exploitation or sexualization of minors in online content while ensuring the law remains consistent with federal government protections governing online platforms. Mr. Speaker, this law has been enacted in multiple states, currently being considered in other legislatures at this time, in Virginia, in Georgia, in Arkansas. Mr. Speaker, we also make sure that those minors who are younger than 14 can be involved in digital content creation with their family's oversight. That monetization is controlled by the family. So with that, Mr. Speaker, I would move passage and would yield for questions.
Senator Lamar, discussion.
Thank you, Mr. Speaker. My question to the sponsor is, if one thing I feel like I know something about is social media, considering it's something that is heavily used since I've been growing up as a young kid. And oftentimes as young people, even when I was under 18, we would come together to create content amongst ourselves to display our talents, our skills, and things like that. That is not necessarily the traditional brick and mortar job that we're used to as citizens. I understand social media is very new. So my question is, currently state law requires that 15% of the earnings of a minor be put into trust. Is it true that your bill would now change that to say that all earnings have to be put into a trust until they're 18?
Senator Wiley to respond.
Mr. Speaker, what this does is this has the earnings by a child would be placed in a trust. Any earnings, all earnings up to the age of 14, those earnings from 14 to 18 could be 100% provided to the content creator under a trust, with our Tennessee Uniform Gifts to Minors Act, and it provides the protections that I mentioned from sexual exploitation, from misuse, and it's only on content creation that is monetized at the amounts that are outlined in the bill, so it has to reach that threshold as well. It does not apply to those more casual opportunities for friends or individuals to get together and create content that's not monetized and reaching those thresholds of at least the $15,000 annually.
Senator Lamar.
Thank you. I understand it, and it's already pretty illegal for any child sexual content to be put on the internet. But what I was saying was essentially, you have young people who are able to start their acting careers very early on. We've all heard of child stars, and they've been able to create content and be able to receive the money that they earn from the content that they're able to produce. Yes, one video that they put together can go viral, and they can earn lots of money from the time they put into creating this content. But now, maybe a minor who may be disadvantaged, who's using this funding for food, for helping out with school fees, for uniforms, or just to be compensated for their talents as an actor, would no longer be able to access that money because this bill creates an all-out restriction for them to access that money because of their age. And I think this should be different, or they should be able to receive the full money that they're owed from the content that they created outside of the already law we have established where they have to put 15% aside into a trust. So I'm definitely concerned about that. Also, I think this is overstepping parents. There are parents who are okay with their minor who may be talented. We have a lot of child actors out there who are very, very talented, but this would prevent them from being able to be compensated for their talents, even with the permission of their parents, with your piece of legislation if this passes. And so I understand social media is new. There are a lot of concerns that I absolutely agree with, and I'm always for the safety of minors. I just think this particular legislation puts content creators at a disadvantage because it basically says you have to be a certain age in order to be compensated for your talents. And I don't necessarily think that it's correct because content creation can vary from a lot of different ages, especially with social media. So that's my concern. I hope that y'all understand where I'm coming from, given my background and extensive professional background and skills in social media. So I ask that you all give this consideration and vote against the bill. Thank you to the sponsor. I have a lot of respect for you. I understand where you're coming from. Thank you.
Oliver.
Thank you, Mr. Speaker. Does the sponsor yield?
Sponsor yields.
Thank you. I would like to know how enforcement is going to be, or how this bill would be enforced when it comes to age restrictions. How are we to determine between a 13-year-old and a 14-year-old? Who is the enforcement entity that will govern whether money is being used properly or being invested into a trust. Like, just how is all that working?
Senator Wiley to respond.
Thank you, Mr. Speaker. Mr. Speaker, the remedies that are outlined in the bill have to deal primarily through the civil court opportunities for the, for the process and for the children. It also allows for these children who might, as they age, particularly after the age of 14 and even into adulthood, be able to object to content that was placed in their name on the platform and request that it be removed. Our civil courts are the venues in which this would be overseen and protected. We've tried to provide the enforcement, not being criminal, of course, but being civil. The remedies focus on restitution to the child, injunctive release, fairness, not punishment, and waivers of a child's rights under this law are void as against our public policy. So those are the remedies that are included in the bill for trying to manage this. And then the parents are obviously involved too. That's part of what the protections are designed for them as well, and for the children as they age. Some children who have been subjected to this as they've aged have found it later in life embarrassing and want their images removed, and they're fortunate that under this proposal that we're going to be able to make sure that the monetization rewards them, very specific criteria for that, and it's enforceable through our civil courts, not criminal.
Senator Oliver to respond.
Thank you, Mr. Speaker, and I appreciate that response. I do have a great deal of respect for the sponsor and what he is trying to do here. However, I do have great concerns about this legislation being too far-reaching into the relationship of a parent and a child and a minor, and I don't think it's the role of government to regulate this type of industry and commerce. I do think that, when I think of other jobs and the emergence of content creators, this has become a viable, job for not only children, but adults alike. And children are growing up to say, I want to be a content creator or a video gamer as a profession. And we don't regulate how money is earned by a minor, whether they're 15 or 16, when they go and work a fast food job, on what they do with those earnings. And so I don't think we should regulate how those earnings are allocated for this type of job. So those are my concerns, also around enforcement, and it just seems a bit intrusive to not trust the parent to make the right decisions. Also, when it comes to trust, not all families have access to those types of resources and assets to invest in a trust. So this doesn't seem like it is equitable in that regard. So I appreciate the sponsor, but I don't think I can support the legislation.
Thank you, Senator Oliver. Further discussion? Is there objection to the question? I see none. We'll be voting on Senate Bill 1469 on third and final consideration. Those members favoring Senate Bill 1469 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Yeas 29, 2 noes.
Senate Bill 1469, having received the constitutional majority, I declare it passed without objection. The motion to reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate's on item number 31, Senate Bill 2206 by Leader Johnson.
Leader Johnson, you're recognized on Senate Bill 2206.
Thank you, Mr. Speaker. For purposes of bringing up a committee amendment, I move passage of Senate Bill 2206, third and final consideration.
That's a proper motion, properly seconded. Amendments, Mr. Clerk.
Amendment number 1 by Senator Yarborough.
Senator Yarborough, you're recognized on Amendment 1.
Did we put the committee amendment on? I don't know. Oh, it's just.
Okay, thank you, Mr. Speaker. Just to clarify, so there's no committee amendment. The
original legislation, I don't think I'm misstating this. In the one big beautiful bill that was adopted at the federal level, one of the provisions that is tucked in is a federal tax credit where individuals can give $1,700 to a scholarship granting organization that can then be used to give scholarships, obviously. So that is not a deduction. It is a full-on dollar-for-dollar tax credit, which is a huge incentive. The legislation at its most basic level opts Tennessee into that program and requires that the department certify a list of scholarship granting organizations that can be the recipients of those dollars. This amendment that I have does not change that at all. It includes one additional provision, which is to require that the Department of Education also ensure that there is a scholarship granting organization that can support public school students and supplemental services such as after-school programs, tutoring assistance. Those types of programs are within the scope of the federal law, and this just facilitates to ensure that when Tennesseans are taking advantage of this federal tax policy, that they can use that tax incentive to support public school students as well as private school students.
Senator Yarborough moves amendment number 1. It's properly seconded. Senator Johnson.
Thank you, Mr. Speaker, and thank you, Senator Yarborough. Senator Yarborough accurately explained the legislation. This is opt-in legislation to allow Tennesseans to participate in a program that's been created at the federal level that would create that tax credit. I do not accept Senator Yarborough's amendment as a friendly amendment, but I am glad that he brought it because it does draw attention to the fact that, in fact, these scholarship granting organizations can, in fact, be utilized for public schools. And I think that that's a really good thing. I can't speak specifically about any that exist at this present time, but certainly they could be created. And there could be a scholarship granting organization that's created specifically for the benefit of public education, and I think that that's a good thing. What this amendment, though, would require the Department of Education to include one scholarship organization dedicated solely to the services of public school students and prioritize that organization. That type of an arrangement is not contemplated in the federal legislation. It's not contemplated in the legislation that we brought. Nothing will preclude an organization being formed for the benefit of public education and for Tennesseans to be able to contribute to that. And I think that that's a good thing. But I don't think that we need to be creating some type of a preference or requiring one be listed first. All of these organizations that are created and eligible, as determined by the Department of Education, will be available, and their mission will be stated, presumably, on the Department of Education website. So that's a good thing, and I appreciate that, but I don't think we need this amendment, Mr. Speaker, and with that, I'll move it to the table, please.
Motion is to table. Properly seconded. Senator Yarborough to respond to the tabling motion.
Thank you, Mr. Speaker. Well, I do oppose the tabling motion, and I'll, just to be clear, there's no mechanical preference that this would set for that one. There would just be, all that is required here is that the Department of Education ensure that there is one of these organizations that is dedicated to supporting public school students. And it doesn't make it the default. It doesn't give them any preference. It just ensures that they are, if a Tennessean wants to take advantage of this tax credit and Googles the page to figure out how to support an organization, that the Department of Education has ensured is going to support all public school students in the state is listed first. And creates an easy access point for someone to actually support public schools. And I mean, I think while it is technically correct that organizations can start these for scholarships, this is a new creation for in that universe, but it is a huge tax credit that will largely, and the assumption economically is that it is going to be used to support private school education. And so just ensuring that there's at least one of these organizations that is devoted to public schools is kind of the least we could do, unless our purpose is to benefit private education at the expense of public education. Because these organizations don't exist. Like, there's no guarantee that they will exist. And certainly no, pathway for the taxpayer to understand which one has worked with Tennessee's Department of Education to ensure that the dollars are going to flow to all of our students. And so, I mean, this macro policy is one that already we are facing real taxing needs on how much of the budget is going to go towards public education, how much is going to go towards private school vouchers, and we're creating a huge tax benefit that is almost exclusively intended to go to private schools. It is entirely possible and within our reach to create an option that at least keeps public schools at the table to get $1. And I don't know why we would be opposed to that. So I would urge members to vote no.
Parliamentary situation, Senator Yarborough moves amendment number 1. Senator Johnson moves it to the table. We'll be voting on the tabling motion. All those favoring the tabling motion will say aye. Aye. Opposed, nay. Nay. I believe the ayes have it. The ayes do have it. The motion is tabled. On the bill as amended, further discussion. Objection to the question? I see none. We'll be voting on Senate Bill 2602 on third and final consideration. Those members favoring Senate Bill 2602 will vote aye when the bell rings. Those opposed will vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 26, 5 nays.
Senate Bill 2206, having received a constitutional majority, I declare it passed without objection. The motion reconsider is hereby tabled. Next bill, Mr. Clerk.
Mr. Speaker, the Senate is on item number 32, Senate Joint Resolution 812 by Senator Watson.
Senator Watson, you're recognized on Senate Joint Resolution 812.
Thank you, Mr. Speaker. Members, I move passage of Senate Joint Resolution 812 on third and final consideration.
Senator Watson moves passage of Senate Joint Resolution 812 on third and final consideration. Discussion. Is there objection to the question? I see none. Senator Watson to close.
Thank you, Mr. Speaker. Members, I had moved this from the consent calendar on Monday in order to have this on the floor to pass this for the Bray family who brought this to my attention. Unfortunately, they have an illness in their family and they're unable to attend. Jen Bray and her family wanted to bring attention to necrotizing enterocolitis, which, members, is one of the most common causes of death in hospitalized premature infants. We celebrate and recognize this illness in May, and the family wanted to bring special recognition from this General Assembly to the issue. I hope that the members in their own districts will take time in May, particularly those that may have children's hospitals with neonatal intensive care units, which care for these children on a regular basis. And as some members have talked about, we've made incredible progress in treating this disorder, but we still lose far too many infants. And it is indeed a tragedy. But within that tragedy, families find amazing strength, and the Bray family certainly has represented that. So with that explanation, I renew my motion to adopt Senate Joint Resolution 812.
Senator Watson moves to adopt Senate Joint Resolution 812. Those members favoring Senate Joint Resolution 812 vote aye when the bell rings. Those opposed vote no. Let every member cast their vote when the bell rings. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 31, no nays.
Senate Joint Resolution 812, having received the constitutional majority, I declare it passed. Without objection, the motion to reconsider is hereby tabled. Senator Hale.
Mr. Clerk.
Mr. Speaker, the Senate is now on the message calendar. Item number 1, Senate Bill 273 by Senator Taylor. The Senate is on House Amendment number 1.
Senator Taylor, you're recognized on Senate Bill 273.
Thank you, Mr. Speaker. We passed this bill last year. The House is just now catching up. They had one amendment, and that was to change the effective date, and I would move to concur with the House bill.
Senator Taylor moves to concur with House Amendment number 1 on Senate Bill 273. You've heard an explanation. Is there any discussion? Seeing none, are you ready to vote? All in favor vote aye when the bell rings. Those opposed vote no. Yeager's aye. Has every member voted? Mr. Clerk, take the vote.
Ayes 26, no nays.
House Amendment number 1, we have voted to concur on Senate Bill 273 with the House Amendment. Without objection, motion to reconsider goes to table. Next item, Mr. Clerk.
Mr. Speaker, the Senate's on item number 2, Senate Bill 836 by Senator Watson. The Senate is on House Amendment number 2.
Senator Watson, you're recognized.
Thank you, Mr. Speaker. Members, Thursday next.
Without objection, Thursday next. Next item, Mr. Clerk.
Mr. Speaker, the Senate is on item number 3, Senate Bill 1739 by Senator Steele.
Senator Steele.
The Senate is on House Amendment number 1.
Thank you, Mr. Speaker. The House amendment does not change the purpose of the bill. It just clarifies that any expansion of the authority is voluntary and locally driven. Mr. Speaker, I move to concur with the House Amendment number 1.
You've heard an explanation. Senator Steele moves to concur with House Amendment number 1. Is there any discussion on House Amendment number 1? Seeing none, are you ready to vote? All in favor will vote aye when the bell rings. All those opposed vote no. Has every member voted? Does any member wish to change their vote? Yeager's yes. Mr. Clerk, take the vote.
Yeas 20, ayes 27, no nays.
The motion to concur has passed on House Amendment number 1. Therefore, Senate Bill 1739 is passed. Without objection, motion to reconsider goes to table. Next item, Mr. Clerk.
Mr. Speaker, the Senate's on item number 4, Senate Bill 1865 by Senator Bailey.
Leader Johnson, you're recognized.
Thank you, Mr. Speaker. Senate Bill 1865 is a bill we passed a little while ago on the consent calendar. It creates the Rescue Squad Grant Program to provide annual grants to rescue squads for the purpose, for the purchase of firefighting equipment and training. The House amendment would require the Department of Commerce and Insurance to distribute grant funding proportionally across the 3 grant divisions based on the number of volunteer fire departments rather than equally as in the original bill. Move to concur.
Leader Johnson moves to concur on House Amendment number 1 on Senate Bill 1865.